seated.
All right, welcome back, members of the jury. Hope you had a pleasant evening. Hope you've had a good morning so far. We're going to go through, I think, the remainder of the day. I know that y'all have lunch plans. We're thinking about 1 o'clock. 1 o'clock should be about right. If there's any issues with that, let me know. Beyond that, keep on letting me know when you need a break. That's important. All right, where we last left off, defense.
Thank you, Judge. Okay, so Dr. Nathaniel, I guess I want to go back to a few things that the state cross-examined Angeles about. And so you remember that part of the presentation where I guess there was a discussion about how far away in the first volley Ms. Perez was from back, I guess from Sergeant Flores.
Yes.
Okay. And Angeles, can we kind of show the distances? Okay. So I think first of all, you're on my age as well.
Yes.
So first of all, you weren't here. You weren't here earlier, but Mr. Cifuentes has been from the very beginning because we didn't have this nice presentation until you heard Angela say it was finalized a couple of days ago, right? But what Ben had been doing from the beginning is he used that screen as a reference. And so what he said and what he was talking to Detective Soto about is he said that you can tell that Sergeant Flores was in front of that window by where he was positioned with the screen. Now in this model, do you see the screen and Sergeant Flores at the corner of that screen?
I do.
Right, like when he's stepping over, he's stepping at the corner of that screen, and we know by the placement of the screen that that's putting Sergeant Flores' head, back of his head, facing the window that Melissa Perez is in.
Correct.
So when Detective Soto said that he wasn't even in front of the window, and Ben had to correct him, Ben was right that Sergeant Flores was in front of the window.
Right, you can physically see that Sergeant Flores is in front of the window.
Right, so, and let's talk about these distances, because Mr. Harris what he was talking about is he said, look, that's 6.5 feet, and he tried to say Ben was wrong about what we've been saying since the beginning of the trial, but I want to walk through that because I don't think he gave Angeles a chance to explain it. When we talk about those distances, that's the distance from Melissa Perez's chest to the body cam facing the other way of Sergeant Flores. You'd agree with that?
Correct. Just so that everybody understands, the measurements that are derived by Mr. Villalobos are all in accordance of where the position of the body camera is. Okay, so body camera to Mrs. Perez's chest for everybody.
Right. And so when she has that hammer, now we talked about it, and Tom talked about the, I don't know, I feel a feedback, but I don't know.
Yeah, I thought it was my hearing aids, but there is feedback in here.
I have no idea what I'm looking for. I don't want to irritate everybody.
I think it's this mic control.
That's you. It's you.
It's this speaker here. Is this yours? Before this trial, I've never seen it. Yeah, it was with the furniture.
You win. Okay. Good. Thank you. So we talked about with Tom. Tom kind of discussed when he went through. I guess he talked about the Vitruvian man, or the idea that if somebody is 5 feet tall, then their wingspan is going to be about 5 feet, 2.5 on this side, 2.5 on this side.
Okay.
Right. So, but we know that she wasn't fully extended with that arm, 2.5 feet, because we know that her arm is kind of in this position.
It's in a cock position.
In a cock position, because that's how she hits the window.
Correct.
However, we do know that her chest is not up against that window.
Correct. You can physically see that her chest is not up against the window.
Right. So if she's a foot back from the window and striking the window with the hammer, what Ben had pointed out the entire time was the distance from the hammer to the back of Sergeant Flores' head, right? And that's going to be a different distance than that 6.5 feet.
Correct. It's the hammer, just so that you understand, it's the hammer that is going to create the injury. Okay, not the person's chest or their head. Okay,
Right.
it's the
And
hammer.
if we took the amount of space that she is, that her chest is from the window, the hammer is at the window, and we know because it contacted the window. And then we took the amount of room or space because there is a, me probably wider than him, but there is an amount of space here, up to 6 inches maybe, that is between the body camera facing the other way and the hammer.
Correct.
Right? And so if you took those distances out, you would still be looking at like 5 feet or maybe less. You agree with that? Okay. So then when Ben, from the beginning of this trial, without the benefit of any of this, has said that the distance from the hammer to the back of Alejandro Sargent's head was 5 feet or less, he was correct about that.
Absolutely.
All right. So now I want to talk about the. Can we play the video again? So I want to talk from Sergeant Thompson's video. Sergeant Thompson, Officer Thompson. Officer Thompson's video, because Travis Thompson, you were able to review Travis Thompson's video, right?
Yes.
Okay. So if we could play this clip from it, and hopefully sound from it. No sound. No, it's fine. Okay, so I played that little clip because I want to go through with you kind of what is happening. So we hear Maria Salinas, we hear her scream Crossfire.
Correct.
Okay, so I want to talk about it because we haven't. I mentioned it from the beginning of the trial. I kind of pointed this out that she is screaming that, and it's part of training. So at this time, you would agree that that Officer Villalobos and eventually Travis Thompson are coming in the front, or I guess coming in that porch door, right?
That's correct.
And at the same time, you have officers coming from the back, and they're coming up this way, right?
Correct.
So can you talk to the jury and tell us about the concept of crossfire and why officers are trained about how dangerous it is?
Correct. What you hear Officer Maria Salinas yelling out as a warning, crossfire, and that means that's an indication to the officers in the front that officers are breaching through the back. And so they're in direct opposition of each other. The officers have not searched the apartment, so they don't know if there's any other person in the apartment that could be armed. And without a warning and the sudden presence of officers, regardless of uniform or not, the first instinct of the officer is on the opposing side, which would be Flores and Villalobos, would be there's another potential threat. And we cannot have those officers engaging each other. So they are trained to give out a warning, crossfire, meaning officers are breaching from the rear, don't shoot.
And then when you have this kind of training, and these officers would have had the same training, that same type of training.
They all get the same training.
Right, and when you have that type of training, you would agree that wherever it is, California, Texas, anywhere where law enforcement is being trained, they are always trained that they have to always be mindful of any other officers that might be in a crossfire situation.
Absolutely. That's standard pistol craft and officer safety. They're all trained throughout the United States in the same concepts.
All right, so Angelos, could you go to the, I don't have your frame numbers, but can you go to the the slide that shows Sergeant Flores' first shot and the distances between Melissa Perez's door.
58. Second one.
Okay. And I think it's 35 seconds. And can we get those distances up there?
Second one.
On the second volley, yes, where I guess it would be Sergeant Flores' first shot.
Eight.
Okay. All right. Now, this is what I want to discuss, and I'm going to use Your Honor, may I use the well for demonstrative?
Yes.
Okay, so I'm going to use this gun. We've talked about it. It may be pointed in different people's direction. It's plastic. It cannot be fired. It is not dangerous. I would not ever point an actual firearm in this situation or any situation at anybody. But in order for this demonstration, it may point at people, you understand?
Sure.
Okay. So when we talk about, and just as an aside, we saw that what was actually measured after Angelos went and did his 3D imaging of the scene and got all his points and got all his dots, what was actually measured was 16.1 feet, right?
Correct.
So Mr. Nisbet, doing basically high school geometry, had come up with a number of 16 feet without having the benefit of this, and he did his demonstration of 16 feet that was with a tape measure. But you would agree that his calculation of 16 feet is almost exactly what the actual calculation was of how far she went.
Yeah, you did a pretty good job.
Yeah, so, all right, so now, as far as, because we've been talking about, Mr. Harris was talking about the distance between her and the people who are shooting, but we've really been pointing out the distance from her to the door. So I want to talk about that in terms of Crossfire. Now, if she is able to get out of that door, does that put her between Sergeant Flores and Officer Villalobos?
It absolutely does.
Right. So if she is between those two, they cannot fire at a crossfire situation at her if she's between them. You would agree?
Of course.
Because Officer Villalobos would be worried that he's going to shoot Sergeant Flores, and Sergeant Flores would be worried that he's going to shoot Officer Villalobos.
Correct.
So they would not, if she gets through that door, they will not have the benefit of using deadly force to combat her deadly force.
Correct. And as an aside, Officer Villalobos, who you see is outside the railing with a line of sight, if she were to come out onto the porch, he can't shoot either.
Right.
Because of the crossfire.
Alejandro, right. So,
Alejandro.
so if he's here, and if he's here in this, so if he's standing here and he's facing this window here, as he is, to his right is Officer Villalobos and Sergeant Flores.
Correct.
If she comes out, he cannot move right and fire at Officer Villalobos and Sergeant Flores.
He cannot.
So he has no benefit of deadly force to protect his fellow officers.
Correct. None of the three involved officers would be able to use deadly force to protect each other or themselves at that point.
So, all the people that are behind, that have drawn their weapons because they're afraid of this charge that she has on, that we are looking at, all the people behind would also be in that same situation of if they fired weapons at her, there would be a high probability that they would hit one of these officers.
Correct. Nobody that was there, none of the officers that were there would be able to engage because of crossfire and what we refer to as friendly fire.
Right. So if she gets out that door, which they believe is unlocked, they are now in a hands-on situation with a woman with a deadly weapon, with a hammer.
Correct.
And I agree. Eventually, they would all hands-on dogpile on her or do whatever they need to do to try. But in that situation, a melee situation, tell us what the risks are and the dangers.
Well, first of all, it's going to be, utter chaos out there. The next thing, we just don't have like a civilian with a hammer. We have a person who's a trained roofer with their favorite tool of work which they're very competent in using. I would suggest probably if you're a roofer and you're using a hammer every single day, all day long, you're probably more competent with a hammer than the officers are with a hammer. And once that woman gets outside, it becomes extremely dynamic because she can strike bilaterally. She can go right to left, and as we've seen with the hammer, you have the claw on one end and you have the striking surface on the other. So all she has to do is just wield that hammer very, very quickly before they can even react to it. Because remember, we talked about the OODA loop. So just picture somebody being on that. Okay, Your Honor, may I stand up for a second?
Yes.
And can I get that, Mr. Goss, can I, no, I want the hammer.
Oh, the hammer.
Okay. Let me just go back over one thing on OODA loop. We're going to do a really easy game that you played with kids, right? So remember this, I'm going to hit your hand, move your hand before I hit it. Okay, so remember, you're always getting your hand hit. And the reason that you're always getting your hand hit is because the actor, the person that's going to hit your hand, they only have to do one thing, hit your hand. What you have to do is 4 things. You have to watch the hand, you have to judge in orientation when the hand is going to hit your hand, then you have to make the decision to move your hand, and then you have to move your hand. So you have to do 4 things. They only have to do one thing. Now, instead of a hand, let's put a hammer in there. And let's put an officer on either side of Miss Perez in very close contact. We're talking a foot, half a foot, 2 feet at most, and she's in there. She's also shorter than them. And so now they have to look down, and she's moving this hammer back and forth and back and forth. Think about your ability while this hammer is moving rapidly back and forth to be able to see it, to orient, and to try to block it or do something. Because the only thing you can do in hand-to-hand combat is at that point block. You can't access any weaponry that you have. It's gone. This is true hand-to-hand combat. The difference is the officers are going to be completely disarmed, and they're fighting against a very dynamic, very aggressive, goal-oriented person that is wielding a deadly weapon. That's the situation that you have.
And so our focus on the door at this point, and when Mr. Nisbet did his demonstrative or his demonstration with Soto, at this point, if she's at 3.7 feet from the door, she gets out of that door, and this whole thing is going to blow up.
Oh, absolutely.
Right. And so, and they know that because they've been trained that if she gets out, she's going to be between them, and they can't try to shoot her if she's attacking them with a hammer because they can shoot each other, right?
Correct.
And so, and just as a note, y'all, Angela's done a great job with all of this. This is something that they could have done. This whole presentation about where the distances were going out with a Leica scanner or some similar kind of scanner and getting all these data points. The DA's office could have done that.
Sure, they could have used their equipment. They could have gone to Bear County and used their equipment. They could have contacted DPS and the Texas Rangers and used their forensic equipment, and they could have also hired a private company like mine that does this for a living. So they had all sorts of opportunities. And by the way, not only did they have this opportunity at the time that this initial investigation took place, that they've had all these months in what we're talking, a couple of years to do this. And they didn't do it. And they could have done it at any time during the process after these officers were charged, just to double check the accuracy or inaccuracy of their work.
And so as far as them being able to do it, we would have seen these distances. The way that we have it and the way that we presented it, and I want to just make it clear, we've been able to see like shot to shot to shot, and we've been able to spend minutes, half a minute, 2 minutes, 3 minutes. But just as a reminder, all of these shots are occurring within like a second or two. is what's happening.
Yeah.
Right? And so, Officer Alejandro was the only one that fired in the first volley, as we explained, because he needed to protect Sergeant Flores. And that's happening very rapidly. And then as she's coming back, all the shots that are happening within a few seconds.
I would agree.
Right. And so we have the benefit of being able to do this, but I would not want it to be, I would not want anyone to be under the impression that they have all of this kind of time that we have to go back and look at it. And you would agree with that?
Correct.
And that kind of goes back to your OODA loop and everything else. I mean, these are decisions that are being made within a second a lot of times.
And sometimes milliseconds.
Right. And so and we talked about that 3.7 feet to the door. And so the 3.7 feet to the door, I believe you said, and I don't know exactly, but I believe you said she was moving, at some time she was moving at 9 feet per second, at some time she was moving at like 6 feet per second.
Correct.
Right, so if you took whatever time this is, I think this might have been the 6 feet per second time, but even at that, and I think it's right there too, 6.6 feet per second is on that frame. What that means is that in half a second, from the time that Sergeant Flores shoots, in half a second, she's gonna be at that door, right?
That's correct.
Right.
That's accurate.
And so, we've talked about, if she gets to that door, all of this is out. And so now they're gonna be in an unarmed, hand-to-hand combat with somebody with a hammer.
Yes, there's no doubt about this.
So and as far as in their, and it goes back to their mindset, and I guess it goes back to Detective Soto's mindset. Now, Detective Soto said, Your Honor, may I press the box?
Yes.
Okay. So when Detective Soto in his warrant affidavit to arrest these officers for murder, he said there was a wall, a window blocked by a television, and a locked door. So as we talked about and we've discussed, we know that the door was locked, but do you also agree with everybody who's testified that based on everything that you've seen, that all of them had a reasonable belief that it's unlocked?
Correct. The collective, there's plenty of evidence here that the collective knowledge of the officers were that they believed that the door was unlocked at the time.
And the state's, I guess, justification and Detective Soto's statement, basically, that they've repeated, that she's only trying to kill or seriously hurt them when they were attempting to arrest her. How do you feel about that statement?
Well, first of all, it's speculative, and it's not borne out. It's not borne out by the fact. So the detective speculates, gets into the mind of the individual. So we need to look at things behaviorally, because we are not allowed to diagnose. We have no idea what's in the mind of the decedent at the time. All we look at is the behavior and the repeated behavior of the decedent. And also, it's already been covered whether the officers had a legal right to make the arrest at that time. So I'm not going to get into the legal things. You've already heard all about that. But the detective, during his investigation, was consistently speculative, guessing, that's what speculation is, guessing, without benefit of any type of forensic facts to support what his opinion was at the time.
And as far as, because I know that you have maintained your ties with the law enforcement community. You are a law enforcement officer yourself. As far as this idea that if Melissa Perez had hit and killed any of these officers with that hammer, that she would have been justified in doing so, what is that kind of idea, what does that do to the law enforcement community?
Well, we live in a very difficult time. I think everybody agrees that. I've got a first responder family. I've got a police officer in my family, one of my sons, and it's very demoralizing. Very, very demoralizing. This is a very difficult job, ladies and gentlemen, and law enforcement officers get stuck with all of the problems that are created by politicians and legislatures. We talk about mental health. The judge earlier today was talking about mental health docket. We get stuck with all of that. We are the people that are the first responders to all of these people that have these problems that law enforcement didn't create. Yet, in literally the blink of an eye, as in this case, we are expected to resolve these issues and these people as peacefully as possible, not use force. And I think it's really important because you see so much of the use of force on television. Statistically, out of all the we make millions of contacts a year with the public, millions. And out of all these millions of contacts with the public, under very diverse circumstances, force, meaning physical force, is only used 1.6% of the time out of all these millions of contacts. And officer-involved shootings, the statistic, you can't even reach the statistic, it's so small. So small. But you see it on television all the time. It's constantly shoved down your throat from a variety of sources. And so your impression of what these officers do is they're shooting people all the time. That is not the truth whatsoever. Like I said, you can't even find a percentage statistic of officer-involved shootings that are fatality shootings in the United States.
And so and I want to kind of move to, with that, so that the jury understands, was there a time in 2022 when Darrell Harris, Mr. Harris, tried to hire you to be the person who was the chief investigator for the Civil Rights Division for Officer Involved Shooting?
Yes.
And had he been successful in 2022, this case would have come in 2023. Would you have told him to file any charges whatsoever on Sergeant Flores based upon his actions on that night?
Yeah, if we were retained, as we are all over the place, we would have looked at this case exactly like we looked at the case on behalf of Cleet, and we would have analyzed the case the same way, and I would have told him unequivocally not to charge these officers.
Officer Alejandro, the same.
All three officers.
Officer Villalobos, the same.
Correct.
You would have said there is no justification to charge any of these officers with any crime based upon their conduct.
None whatsoever.
I'll pass the lead.
Dr. Martinelli, I have a question regarding Graham v. Connor, and I think you heard Lieutenant Majeka speak a bit about that. I want to ask you, based on your training, your education, and experience, and I take it you are familiar with Graham v. Connor?
Yes, sir.
Okay. And can you tell the members of the jury the importance of that United States Supreme Court decision?
Sure. It's probably, of all the different Supreme Court decisions and appellate court decisions, it's what we consider to be the preeminent decision, because it comes from the United States Supreme Court. And I think Lieutenant Majeka was eloquent in his discussion, but I'll just repeat it. It provides us with guidelines on when and when not to use force. Okay? And so these guidelines are not only taught in the state of Texas, but they are taught nationally. And so it's referred to, in my line of work, it's referred to as a codified, it's a recognized all over the country, accepted, applied, and trained law enforcement practice. So you cannot go through a police academy in Texas or California or anywhere else in the United States and not specifically be trained in Graham v. Connor when you are being trained in the use of force and Fourth Amendment, right? Unreasonable searches and seizures, it comes into that. So it's an extremely important case. And this case, to me, as a professional and a former law enforcement officer, there is and I'm just going to paraphrase what the Supreme Court said, these are rapidly evolving situations that are tense and uncertain. And during these situations, these incidents, when we are analyzing these incidents and rendering findings and opinions, the court was very specific that we must look at the actions of the officers from the officers' shoes, from their standpoint. And we are precluded, we are prevented, we are prohibited from using what's referred to as 20/20 hindsight in that analysis. So it's very important that you understand that, just like I understand that, and Lieutenant Machaca understands that. These are strict guidelines that we're provided with. And secondly, when agencies write their use of force policies, and I write use of force policies in Texas. I just finished doing the whole use of force policy for the Hidalgo County Sheriff's Department just a few months ago. We mirror the Graham standard into the use of force policy for our law enforcement agencies, just so that you understand that.
And Dr. I want to follow up on when the U.S. Supreme Court talked about these tense, dynamic, rapidly changing circumstances that reasonable police officers are faced with on a daily basis. I know when you have a shooting like this occur, somebody at some point is going to look at it, right, and judge it. Hopefully they're going to do a very good job and look at everything and be fair and unbiased in their judgment. However, when the Supreme Court talks about don't use 20/20 hindsight, that almost seems to suggest, well, nobody should really look or judge the officer's actions. So can you just expand on that if you can, and just explain a little bit more, what does that mean? And I think you already have, you got to step into the officer's shoes, but what's the significance of not using 20/20 hindsight? I think one of the quotes too was, you can't examine this from the comfort of a judge's chambers. Can you expand on that concept?
Sure. Let me lay down a foundation for you first, okay? And it may not have been discussed, or maybe just a term here or there, but let me explain what you've heard during the course of the trial. There are two standards. There is the subjective standard. So generally defined, subjectivity. Subject is a hunch, a suspicion, even an educated guess, all right? But it is non-forensic. It is non-factual necessary, right? The objective is something that has specific facts to it that can be proven and demonstrated and tested upon again and again. So when we are investigating an officer-involved shooting, and we are using science-based methodologies, if that's applicable, if we're able to do that, like in this case, what we have to do is remove all the subjectivity from that investigation. We must use the Graham standard in our analysis, but then it must be supported, whenever possible, by forensic facts and evidence. And so in this case, as you've been seeing, especially yesterday with Mr. Lelalu's presentation, we have been able to use applied science, well-regarded, peer-reviewed, tested time and again, very accurate applied science of photogrammetry and video analysis to get the forensic facts that we need, so that when we look back at that Graham standard through the eyes of the officers, we can tell you whether or not, accurately, we can tell you whether or not the facts, the objective facts and evidence support what the officers have stated as to their justification of shooting in the moments that they fired. That's what this is all about. Did I handle that okay for you, Counselor?
Yes, sir. And lastly, because obviously we're all human and only human, is there anything that we have not asked you, or that any testimony you think needs correcting or elucidating more for the jury? Anything?
Yeah, I'll just leave you with this before the prosecution asks me, their questions. There are basically two arguments, the way I see it, is my personal opinion. There are basically two arguments. One is an emotional argument. Where you can feel sorry for Ms. Perez. I don't think anybody in the courtroom here doesn't feel sorry for Ms. Perez. But that's an emotional argument. And what we practice, and what I suggest needs to be practiced, is stepping away from an emotional argument and looking at the actual proven facts and forensic evidence, because that's how we determine whether or not the officers acted as the Supreme Court wants them to do, in the state of Texas wants them to do, in an objectively reasonable manner. And so when we do that, we have to move the emotions out of the way, and we look at what the truth is that can be proven. That's all little advice. That's all I'd like to share with you.
Thank you, Dr. Martinelli.
Thank you, Counselor.
May I?
Yes.
Good morning, Martin. How are you?
Good morning, sir. How are you?
My name is David Lunan. I obviously work for the state of Texas, right?
Yes, sir.
You've been affiliated with law enforcement for how many years?
I started in 1975.
50?
Yeah, I'm coming up to the big 50.
Okay. Like Lieutenant Majeka, you had used words like us multiple times when referring to police officers and their training and the like and the things that they experience. Would you agree with that?
Yes, I've said the word us.
And given that long and committed service record that you have and your committed service record, it should surprise no one that you are a strong advocate for what police officers do. Is that right?
Well, I'm an advocate for law enforcement. I'm an advocate for criminal justice, and especially the justice part of criminal justice.
And the law enforcement community is much like a brotherhood or fraternity, maybe a lot like being in the military.
Like being in the military, being in the priesthood, being involved in any career path where we take risks and we make sacrifices.
And your work on this case and your testimony that you're providing is being paid for by CLEAT. What is CLEAT?
The Combined Law Enforcement Agencies of Texas. It is think of it as a legal defense fund for police officers.
Okay. So do all police, it's kind of a union? Or is it something every police officer contributes to?
Yeah, I believe so.
Okay.
Well, I believe that there's a couple of different legal defense funds in Texas. The only one that I'm personally familiar with, because of a relationship, is CLEAT.
Okay. And CLEAT is a Texas program. It's not a nationwide program.
That's correct.
Right. And I mean, how many hours have you worked on this?
Probably around 120 hours.
And how you bill for your work?
We have a billing schedule depending on the type of work I do.
Yes, sir.
There's a difference between review analysis and if any reports are written, and then there's a different for a consultation with attorneys or any testimony that I give. So I'm using testimony time at this point.
Can you give me a ballpark figure of how much you expect to earn from your involvement in this case?
Well, I can only tell you about how many hours, and I think I have. I've spent somewhere around 120 hours in this case.
Okay, I mean, then what's your hourly rate, then your minimum hourly rate for what you're doing?
Sure, but first of all, let me say this. I'm a salaried employee. I own a corporation, so I am a salaried employee. So it's not like all of this money is coming to, Ron Martinelli. It comes to a company. But I can answer your question directly.
Okay.
For analysis, review, and report writing, I charge $400 an hour, and for testimony and consultation, that's at $500 an hour.
Okay. And you're an employee of a corporation?
I am.
What's the corporation?
It's a limited liability company, Martinelli and Associates Justice and Forensic Consultants, and we have a staff of 20.
Now, when were you retained in this case?
Hang on one second.
Okay.
On October 16th, 2023.
2023, October 16th, 2023?
Correct.
And when did you get the discovery materials to review?
Well, I have to tell you, throughout that period, we have continued to get discovery materials all the way up until, I think, this last week.
And did you get every body-worn camera within the first batch of discovery that you got?
I can't tell you exactly, but I can tell you that we received all the BWC in this case.
Okay, and then how long after watching all the body-worn cameras and reading the discovery materials were you able to form an opinion as to whether or not the officer's conduct was reasonable in shooting at Melissa Perez?
Once we took a look at all the BWC videos and I had reviewed the police reports in the case and the statements, because I needed something to compare, and then I started working with Mr. Leilaglu. We'd actually gone out to the scene together to do the scan. Once we started working together for the analysis, I was able to render some preliminary findings that supported the officer's justification for using force against Ms. Perez.
So is it your testimony then that you weren't able to form that opinion until you got the results of Mr. Leilaglu's work?
Right, because as I've discussed, my work is objective. I have to use the science to help me with the analysis of what's happening. You just can't, because if you just take a look at the BWCs without the science and the analysis being done, you can make very quick judgments. And a great example is Detective Soto, right? And that's not us. We don't do it that way. We use objective scientific analysis to render findings and opinions.
And you talked about your career as a patrolman, field training officer, supervisor, training coordinator. You did tours in special crimes, working undercover, as well as experience in high-risk entries. Is that right?
Yes.
Tell us what a high-risk entry is.
Anytime that you are breaching into a location with other officers and you're armed and you believe other people inside that premise might be armed, that's considered to be a high-risk entry.
And did you participate in that practice? Did it require any specialized training?
It does, yes.
I mean, you wouldn't task an officer with the responsibility of doing that unless you had trained them as a department, right?
Yes, the officers receive officer safety training, they receive breaching training, they train in weaponry, and they understand what the basic high-risk entry is. So let's separate different types of high-risk entries, right? So this case was, if they were able to accomplish it, this would have been defined as a high-risk entry. Entries to effect warrant arrests is another type of high-risk entry. Another time would be what we call a RAMI entry, or we're in fresh pursuit after a fleeing felon who might be armed or whatever, and we're going into a premise, we're breaching, which means entering, forcibly entering a residence. That's another high-risk entry. And then also special weapons and tactics and what we call operators, where you see on television all the time, they're all geared up, they got all of that stuff. I got the Bearcat, all of the fun tools. That's another type of high-risk entry. So there's several different types of high-risk entries.
And in all those operations of a high-risk entry, the objective is that no officers get hurt and no people inside get hurt, right?
Hopefully that's the objective if we can accomplish it. Sometimes we can, the majority of the time we can, other times we can't.
I kind of liken it to dog catchers. Right, animal care services or people that do our dog catching in town, right? And they're trained to be able to remove an unruly stray from the street without hurting the animal and hurting themselves. Would you agree?
Yeah, my dad was a veterinarian. I had a lot of experience being bitten by dogs.
I mean, and they're trained adequately so they can do that. I mean, I don't see on the news any dogs getting shot in the street, right?
Well, not by animal control people because they're unarmed.
Yeah. They're able to accomplish that task unarmed.
Yeah, but often they get bit.
Yeah. So the training you were talking about on the high-risk entry, Does it include de-escalation?
It can, yes.
Okay, tell us a little bit, I mean, you've written a lot extensively about de-escalation, haven't you?
Yes, I have.
I'm going to object to this. And in particular, this violates a recent court opinion that came down yesterday by the Court of Criminal Appeals. It's called Jeremiah Navarro versus State. It came down yesterday, November 6th, and basically, in that opinion...
Your Honor, I would object to him speaking. He wants to approach the bench instead of him just telling the jury.
We can excuse the jury if need be, but this is improper, this is irrelevant under 401, 402, 403, and the court has already ruled that tactics is not a basis to challenge the decision to make the arrest, and under Texas Penal Code 604, which deals with causation, and the Supreme Court decisions that say that officer-induced misconduct is not a basis for a person to be justified in resisting arrest.
I'll sustain.
Are you familiar with a case called Barnes v. Felix? Barnes v. Felix, Supreme Court case?
Okay.
Are you familiar with it?
I don't know right offhand if I'm familiar with that case.
Okay. It was returned this year in January. Are you aware of that's pretty important to know Supreme Court cases that deal with an officer's reasonable use of force and deadly force, wouldn't you say?
Yeah, I think I would refer to Broughton v. Texas, which is a Texas State Court of Appeals case, which discusses the same guidelines for the use of force. And I'm sure you know that case.
Well, Barnes v. Felix, right, stands for the proposition from the Supreme Court that in evaluating an officer's reasonable belief, you don't focus on the moment of the threat, you focus on what?
Are you talking about pre-shooting conduct?
I'm talking about the totality of circumstances that came from Graham v. Connor, right?
I understand that, but what we're dealing with is the moment. If you want to talk about Graham, then we're going to talk about in the moment, because Texas is an in-the-moment state. It's not a Ninth Circuit Court of Appeals case where we're dealing with pre-shooting conduct.
Well, I don't know. Are you not familiar with Barnes v. Felix then, a Supreme Court case?
If you would like to parse it out for me, Counselor, and you'd like to ask my opinions on that, I'm more than happy to help you.
Okay. Well, Graham v. Connor talked about the totality of circumstances, right?
It did.
In evaluating the officer's conduct, right?
Yes, sir.
And Barnes v. Felix modified that opinion by saying you don't look at
I'm going to object, Your Honor.
just a moment.
I'm going to object. That's a misstatement of what Barnes v. Felix said. And you cannot misstate what the Supreme Court said in Barnes v. Felix. And if you want to excuse the jury, I can explain and address that issue. And I think it's also getting dangerously close to opening the door to our judicial notice under our motion 202.
I was thinking that same thing. I'll sustain.
In the training that officers receive in conducting high-risk entries, are they trained in the use of non-lethal and less lethal force?
They are.
They are? What kind of training do they receive regarding the use of those kinds of tools?
Sure. For non-lethal force, then we talk about psychological presence, which is having more than one officer present. And what we mean by psychological presence is if it's just one-on-one to a resistant person, they might want to consider resisting the individual. They might say something, well, I think I can take that guy on. I'm not going to let this guy arrest me. And so that's why we'll bring in another officer, or maybe 3 officers, because psychologically, the individual that's resistive is thinking, well, I might be able to take that one guy on, but I think eventually it's going to be dogpile on the rabbit and I'm going to lose. So that's the psychological application of what we call non-forceful intervention. The next one is tactical negotiation, dialogue, communication, and a more current phrase is called de-escalation. And so the purpose of dialogue and communication is to attempt to develop a rapport for the individual and try to maybe assuage any concerns they have about the arrest, and then try to convince them to submit to custody. So when we talk about tactical negotiation or de-escalation, we are trying to get the individual, who's our audience, our resistive person, to submit to custody without any use of force being used. In other words, a peaceful resolution. Beyond that, we can also increase that level of dialogue to de-escalate. So, like right now, at a very calm voice, I'm talking with you like I would try to convince someone to give it up and put your hands behind your back. But other times we might need to raise our voice and issue loud directions and commands, because sometimes people are under the influence, or they're not focused, or there's an issue with them concentrating, and we also need to provide them with at least a foundational understanding that we are going to take them into custody, and we need them to comply right now. And so we might use a loud voice at them. Sometimes we might even swear at them, right? When you hear somebody say, "Get on the effing ground," or something like that, because now there's more urgency, there might be more risk associated with that, and so that's the dialogue to yelling or maybe even swearing from time to time. The next one would be the use of force. So use of force is everything from physical arrest and control techniques, where we are grabbing somebody, maybe putting what we call a twist lock on them. Physical control can also be some pain compliance, when we're exerting a little bit of pain on it, which is designed to, using the pun, force them into compliance. So that's a compliance generating thing, and then we'll handcuff them. We might have to use defensive tactics in the case of active resistance, dangerous resistance. We might have to use some martial art, take them to the ground, put them in a control position, so that's DT, including punches and kicks and things like that, depending on the severity of the resistance and the risk that they're presenting to us. And then we can go to weaponized force. So weaponized force would be like a chemical agent, like pepper spray. You all know pepper spray, right? And so we might pepper spray the individual because it creates both a psychological and a physiological response, pain, blinding, something like that. And that's used for controlling force. We might use a taser, which is an electronic control weapon, and you're familiar with tasers from this case, and also the limitations. So don't forget, chemical agents have a lot of limitations, and electronic weapons have a lot of limitations. We might go to an impact weapon or a baton, right? You heard of the batons, ASP, it's an expandable baton, and which is basically a steel pipe, right? And we might use that for two purposes, not just hitting somebody, but using leverage when they're on the ground and trapping their arm and bringing it behind their back. So we can use that defensively. We can also use less lethal munitions, which are things like sponge rounds, like a 40 millimeter sponge round. It might be a plastic round. It could be a rubber bullet. It can be a pepper ball gun. Those are impact rounds. And then we have, depending on the state, we can use what we called a carotid restraint, which you see this in martial arts all the time. You might call it a blood choke, or you see this all the time if you watch martial arts. What is it? And then we can go to canine. And so obviously, you know what the canine is used for, and then we go to lethal force. So there's a whole range of both non-forceful, pain compliance, less lethal, and lethal force that we can use.
And as part of your training in making these high-risk entries, is there also something called making the threat assessment?
Yes,
And you've written about that.
I have.
And you've trained on it as well.
I have.
And in that making that threat assessment, have you created 5 rules called the art of force?
Yes.
Okay. Let's talk about that. In Rule 1, is you can't seek to control others unless you are first in control yourself.
Correct. You don't want to get emotionally captured when you're involved in a situation.
Describe what you mean by emotionally captured.
Sure. You don't want your emotions to take over your objectivity, right? So you got a job to do, you need to focus on that job, and you need to accomplish that mission, which is taking somebody into custody or defending yourself.
And how can becoming emotionally captured affect your actions?
It can lead to excessive force.
You had talked kind of about talked a lot about the physiological and psychological responses to someone under stress, right?
Yes, sir.
Are those same kind of endorphins and chemicals released, from the brain in this situation of being emotionally captured?
Well, it can, yes. Yeah, it doesn't happen independently.
Rule number 2, manipulate the environment. What did you mean by that?
Well, the environment always presents a challenge, and so the officers want to, whenever possible, can't always be done, but whenever possible, manipulate the environment by finding a tactical way to approach an individual or to protect one's self.
You write here that how you can exploit the same environment to succeed in safely and effectively taking a resistant or threatening subject into custody.
If it's possible to do so, and it also has a lot to do with the subject and how resistive they are, how gory they are, whether we have to deal with mental health issues or some sort of intoxicant.
But the training calls for consider that as a way to do this safely.
Sure.
Do you agree?
Yes, I do.
You talked about under your rule number 3 that there are 5 components of an arrest, and you have to be sure before you make that entry that you can accomplish each one of them. Did I state that accurately?
Yes.
Describe that for the jury.
Sure. So the 5 components of an arrest are basically the dialogue communication, the approach, the laying hands on of a person, then doing what we call an arrest and control and handcuffing technique, and then searching them in preparation of transportation.
And you write here in this article, and I say you write in this article, but you train on this too. It's not just you wrote it in this article, right?
That's true. I appreciate you reading my articles, by the
Okay.
way. Thank you.
Okay, I haven't had anything else to do. You point out that after considering the circumstances, you believe that you cannot safely complete or accomplish all 5 of these arrest components. Don't attempt to make contact.
If that's possible, yes. But sometimes we have to make contact.
Well, if possible, right? You talked about...
Yeah, if possible, sure. All things are possible.
That leads us to the rule number 4, which is, well, actually, I can jump to rule 5 and come back to rule 4, but time is your friend. Time and distance are your friends, right?
Yes, or they can be your enemy.
Yeah, we'll talk about that. Distance and cover are your friends? Is that your rule number 5?
They can be, yes. We've talked about that.
Okay. Well, discuss with us how distance and cover can be your friends in approaching a situation where a high-risk entry is necessary.
You want me to discuss that?
Yes.
Sure.
I don't just ask yes or no questions.
Oh, okay. No, go ahead. What is your yes or no question?
I said I'm not asking you a yes or no
Oh,
question.
all right.
I'm
Well, sure.
allowing you to discuss what you meant in approaching a high-risk entry and making a threat assessment about how distance and cover are your friends.
Sure. And we can take this one, this particular thing. So I think we've talked about this before. It's always better to try to take somebody on and arrest them. If that's the goal now and you've made your decision that you're going to effect an arrest, it's always better, and I think you'd all agree, that you want to take somebody on when they're not armed, right? When they're not armed. And so in preparation you look at the resources that you have available to you. And then we also spent some time yesterday talking about preclusion, right? You can have the techniques, you can have the tactics, you can have the weapons, but if you are precluded by one thing or another to be able to use a certain technique, tactic, or weapon, then you need to move on. So we consider our resources, and there's been a lot of evidence here that the officers considered the resources, the supervisors considered the resources, and they made a rudimentary plan to enter the premise. And so they're looking at the environment. Okay, so in this particular case, there's been a lot of discussion about this glass door. And so remember that the collective knowledge of the involved officers was that that door had been unlocked by Officer Villalobos. And so when they are looking at a time to breach entry into that house, into that apartment, that small environment, they are waiting for an opportunity for Ms. Perez to be unarmed, right? And if you saw, when they made their movements, they stayed back, they continually stayed back, they continued the dialogue, and then when they believed that she was unarmed, that's when they started making attempts to enter. But what happened then was Ms. Perez precluded them by continually assaulting them. So there was a plan, and they're following that methodology.
You're right here. Whenever possible, utilize and maintain distance and cover from any resistant and potentially violent subject you intend to arrest. You agree?
I do, and they demonstrated that.
And distance allows you to observe more and prevents visual distortions such as perceptual narrowing or tunnel vision. What do you mean by that?
Well, you can obviously see more. Can I use a counselor for a second just to do a demonstration of what we're talking about here?
Sure, there's a volunteer just stood up.
Great.
Come on down.
Promise not to hurt you. But I need you to stand there.
Okay, wherever you want.
Okay. So let's do this for a second. Let's go really, really close. Okay? So how far down my body can you see?
Without moving my
Yeah,
head
without moving your, how far down your body can you see?
to your hands.
To my hands. You see that?
No.
No. So you really can't see my hands, can he? He thinks he sees my hands, but he can't see my hands, or I wouldn't hit him in the throat. I promise not to hurt you. Okay? So that's a great example. Okay, so now let's step back a little bit. No, not you, I'll do it. Okay? So now, how far down my body can you see?
To your feet.
You can see my feet. Okay, so when I make a move, all I need you to do is go through the OODA loop and just move back. You ready?
Ready.
You see, he was able to do that. So that demonstrates the reactionary gap that we talked about, right? Distance versus reaction time. So when I'm up close, he thinks he can see something, but he really can't. And he has like 0 reaction time. Because remember, I only had to do one thing. I only had to just hit him in the throat. And he had to well, then he just took it, right? Because he couldn't go through it. But back here, he's able to do it quite easily. All right? Thank you.
Thank you, Jason. And this distance and cover also provides you to have, enhances your hearing, your situational awareness, and lengthens your reactionary gap.
I think we just demonstrated that.
So it's a tactic for preparing yourself for what could happen, right? And not
Correct.
being caught by surprise.
Correct.
Right? You had mentioned that she had disarmed herself, but I mean, she had taken the weapon and set it down a few feet from her,
Yeah, momentarily, yes.
right? I mean, it wasn't in a lockbox.
No,
It was visible to everyone, right?
I don't know if it was visible to everyone, but I will agree with you, she set it down.
And those it wasn't visible, but I heard it from others saying this is where it was.
Yes.
Maintaining distance from resistant and or threatening subjects presenting as agitated, not psychotic, or those intent upon choreographing a suicide by cop scenario significantly reduces the acute paranoia these subjects might experience through space and time compression, right?
Correct.
right? So it's not only doing something for the officers in proceeding and preparing themselves for any kind of attack, it also is de-escalating to the subject, keeping time, keeping distance and cover away from them.
Well, no, not necessarily.
Go ahead and explain what you meant by that.
Okay, fine. So, with some people, you can absolutely employ that tactic. You can absolutely do that. You can keep distance, and you can wait it out. But in other people, that especially people that are goal-oriented, and they don't want you to arrest them, but yet you need to effect an arrest, and you have a lawful right to effect an arrest, then that may not work. And so don't forget, and we've talked about that, many times in this case, time and distance compression work both ways. So the officers can create distance whenever possible. The subject can create distance by running away from the officers, but the subject can also compress distance, which automatically compresses time. So in this particular case, and especially with Sergeant Flores, that I spoke about yesterday afternoon, you saw that he did every single thing that he could possibly do to create distance between himself and Ms. Perez. But Ms. Perez attacked him with the hammer, which caused the sergeant to get wedged into a corner, which forced a lethal defensive response. So, the whole time and distance compression works both ways.
You had written, again, this article under Rule 4, that if at all possible, avoid this time compression you're talking about.
If you can. You can't always do it, and especially in a case like this where the person is goal-oriented and repeatedly attacking the officers.
Well, would you agree that in the fatal encounter they had, it was the officers that created the time compression by approaching the patio, jumping the patio, and going to her door? That was the initial time compression that they did, right?
I really wouldn't call it that time compression, because what they're doing is they're moving into they had a plan, they had a rudimentary plan to take somebody into custody. There had been a lengthy period of de-escalation, which was ineffective. The officers had the legal right to enter into the residence to effect an arrest. They waited for an opportunity. They believed the environment favored them when they believed the door was unlocked. And then when they saw Ms. Perez disarm herself, that's when the officers made their decision to attempt to breach entry, which brought an immediate forceful response, a resistive response on the part of Ms. Perez.
You had used that word before during your direct examination, that it was a rudimentary plan. What do you mean by that?
It was a simple plan of arrest.
Do you think, from hearing what we could hear on the video and the body-worn camera, that everyone understood what their roles were in this rudimentary plan?
I believe they knew what their role was in taking her into custody, and they were working towards that plan. It's pretty evident when you watch the videos that Officer Villalobos was reaching through the door to unlock the door. I believe you can even hear the door click, indicating to a reasonable officer that he had attempted to unlock the door. And then they had positioned themselves tactically in a way that once the door was open, they could breach entry into the apartment. And they had, at the third officer, they had lethal oversight, and they also had an officer with a taser. So that is what you call a rudimentary, simple plan of breaching an arrest.
You kind of went on in here to talk about the importance of not compressing time, or time compression, when possible, and you explained your reasons for that. You said the trick is to follow Rule 1, which is not to become emotionally captured, right?
Right, and I saw no evidence of any emotional capture on any of the three involved officers here.
And become so emotionally captured to an event with a resistant or threatening subject that you become unreasonably phobic and adrenalized to the point that you rush into a situation that you don't have to.
Correct, and I saw absolutely no evidence of that in this case.
but someone who's emotionally captured that could be sufficiently adrenalized to rush into making a decision that they didn't need to. It probably wasn't good police protocols.
Sure, I'll repeat what I just said. I didn't see any evidence whatsoever of any emotional capture on the part of Sergeant Flores, Officer Villalobos, or Officer Alejandro. I saw absolutely no response that was emotional.
All right, let's take a short break. All right, from here. perfect. That'll be perfect.
I know.
That works out then. That's a nice way to round it up.
I just had another judge that did the same thing. Yeah, did the same thing.
Can't ask for better than that.
May be seated.
All right, welcome back, members of the jury. Stay.
Thank you, Judge. I don't want to refer to too many more of your articles, but you did write a few about the Tuller drill, right?
I'm sorry, can you repeat?
The Tuller drill, you've written articles and taught about the Tuller drill.
Yes,
I think you mentioned a little bit of that on direct.
That's correct.
Right? This actual was first published, what was it, in the 1970s? When did the Tuller drill first come to mind of law enforcement?
well, it was in the 70s, and it really, it started with then Sergeant Dennis Tuller from the Salt Lake City Police Department. And basically, he's a firearms trainer, and, as trainers, we're always trying to engage our students, our officers, and we're trying to, teach them something new, so it's not boring. And so he just came out with a really nice experiment, very simple, to judge action-reaction, right? And so he took a bad guy with a rubber knife, and he put him out about 21 feet, and he started with each officer that he was training, and they had him stand in the center of a circle, and then had the guy with the rubber knife run at him, and the officer had to draw from a holstered position to see, and using what we call simunitions, or fake rounds, blood rounds, if you could hit him. And so that's what that was all about. And so they determined that within 21 feet, a person rushing at you, the officer would not be able to successfully engage that individual for self-defense without being seriously injured or killed. Now, I did similar experiments to that. We actually televised those. Those were on CNN. And I did, there's a very famous author in New York. His name is Malcolm Gladwell. And Malcolm writes for, I think, Atlantic Magazine, and he had written about officer-involved shootings, and he was critical of officer-involved shootings. So I invited him to come out to Bernie, because that's where I live, that's where our living lab is, and come out, and we put him through 4 different scenarios as an officer. And when he shot when he shouldn't have shot, and then other times, when he was supposed to shoot and didn't shoot, he got killed. And so we took that and turned that into research, and then published an article based on that. So that's what the prosecutor's talking about here.
Yeah, essentially, I think your critique of the Tuller drill is it's too simple, right? It didn't investigate the number of variables that would be involved in that kind of just 21-foot rule understanding for officers. Is that right?
Yeah, that's correct. Very good.
And what kind of variables did it not consider?
It didn't consider experience, both time on the job where you've experienced acute threats. It had a lot to do with weapon handling skills. It had to do with holster. It had to do with, again, your pistol craft, and how many times you've been out to the range, or how many rounds you fire on a continuous basis. And so I compared the variables as being rookie police recruits in their first week of firearms handling to Tier 6 Navy SEALs, right, who have fired millions of rounds. And I found that depending on the experience of the individual, meaning all of their experience, right, and their experience using their handgun and their holster system, things of that nature, that actually the 21-foot rule, which had sort of become dogma, I said it was never intended to be a rule. I spoke with Sergeant Tuller, Lieutenant Tuller then. He said he never designed it as a rule. And I hypothesized, based on our research, that really you could get back as far as 60 feet when you attacked an individual before a rookie police officer with a threat level 3 holster could draw and fire their gun and hit that person without being killed. So there was a lot of variables involved in that.
Let's talk about the aspects of the criminal investigation that you reviewed by Detective Soto, right? You had, I don't know the word that you necessarily used, but you believed it was inadequate,
Yes, sir.
right? Tell me, in your opinion, what evidence he failed to collect.
Sure. He collected, it isn't really what he collected, it's what he did with what he had, and then based on what he had, which were known things, the BWCs, interviewing people, the photographs, the autopsy report, the ballistics, what he failed to do with that information, that evidence, that would move the investigation from speculation to objectivity. And so the object is for investigators, detectives, and someone like me, we are not supposed to advocate for people or entities. We are supposed to advocate for forensic facts and evidence as best that we can determine them, and you've heard this term and I've used it, to a reasonable degree of professional reliability. So it's a fact-based investigation, and we need to remove the confirmation bias and the implicit, the subconscious bias from our investigation. And so as information, we call it discovery or evidence, is coming to us, we need to analyze that, and we need to be saying to ourselves as detectives, what more do I need? And so going back and, first of all, you need to ask the right questions during an officer-involved shooting to your officers and to your witnesses. You need to know the questions to ask them. And in order to do that, you've got to look at the BWC evidence. And based on that, that gives you a lot more questions to ask. And then you should be doing the scanning and getting ideas conceptually and accurately of what that apartment looks like, right? What does that apartment look like? What does that porch look like? What are the constraints? And then you may want to go back and ask more questions or do further analysis. And to the point where you come to a decision as to whether you believe the officers within, you heard this term all the time, the totality of circumstances and in accordance with what Texas laws are in the United States Supreme Court, whether what the officers did ultimately, even though very difficult, was objectively reasonable. Did they act in an objectively reasonable manner? That's how you conduct the investigation.
Do you believe that on an OIS, officer-involved shooting case, that the agency that the officer works for or employed by should be the one doing the investigation?
Well, that depends on that's a great question, by the way, Counselor.
Is that my first one?
No, they're good. They're all good. That really depends on the sophistication and the resources of the agency, right? So some agencies are very sophisticated. They've got a good CSI unit. They have good detectives, well-trained detectives, experienced detectives, and they have the forensic ability, not only the experiential ability, but they have the forensic ability to be able to self-investigate. Other agencies, and for instance, I work with the Texas Rangers. I've worked with them on officer-involved shootings. You can reach out to another agency, right? So you reach out to the DPS, to the Texas Rangers. You can reach out to other counties, and I practice throughout the United States, so I'm familiar with different types of OIS shooting teams. And so sometimes there's a regional, as you know, Mr. Prosecutor, there can be a regional OIS shooting team where you get very experienced detectives and CSI people from maybe 3 or 4 departments. They join together, and then in a joint task force relationship, they will investigate officer-involved shooting. When I work for the United States Department of Justice, I do strictly officer-involved shootings for them. They will also, besides maybe having the FBI look at the investigation, they will call in other professionals to check the work, to make sure that the United States government is doing it right. Okay, so there's a lot of different ways to do that.
Is there a concern for bias involving when their own agency looks at their officer? Is that a concern in the law enforcement community?
Oh, absolutely. This is a great example of bias, where the investigation was just in its infant stages, only hours old, and then my understanding in listening to the testimony was that the chief of police, Mr. McManus, made a decision through command staff, the upper echelons of command staff, that this was not a justifiable shooting, and that was apparently, sent down the line to the investigators. And so there was a tremendous amount of confirmation and implicit bias already before the detectives really even got at the beginning of a handle on the case.
I guess the question I had for you was, isn't the concern that the agency would be biased for the officers, not against them?
No, not necessarily. We live in a very political time. I think Mr. Harris had brought up a couple of days ago, he mentioned George Floyd, which is a case I'm infinitely familiar with and have analyzed. And he said, well, after George Floyd, well, when I hear something like that, that tells me that there's a bias already involved in this case, because they don't want this San Antonio shooting to reflect anywhere on the George Floyd shooting. So, because they don't want riots or they don't want unrest in San Antonio. Well, San Antonio is not Minneapolis, Minnesota. But look at that just by the prosecutor using the term George Floyd. To me, that was a trigger word. And it's something that you should all, in my humble opinion, you should take into consideration on how they looked at this investigation.
Would you agree with me that it's very rare indeed that when you do an investigation into a criminal episode, that every minute of it is video recorded and audio recorded?
Would I agree that not every minute is video recorded or audio recorded?
No,
I'm sorry.
Would you agree that it's very rare that in a criminal episode that investigators have before them the entire video and audio recording of the event?
Oh, thank you, sir. Yes, I would agree.
Okay. And in some of the things that you testified before, the problems you saw and the remarks that you made in forming your opinion that the officers were or were not justified was the fact that what the officer said was different than what their video showed.
Sure,
Right.
that can be the case, and there are also some psychological reasons for that. But still, what's the need for exigency in coming to a conclusion, a premature conclusion in a case like this? What are the exigent circumstances that would cause the agency or the district attorney's office to come to a premature conclusion, as without meaning premature, they hadn't looked at all of this stuff, and now all of a sudden now there's a decision being made that they're gonna charge these officers. There's no exigent circumstances here. They had 2 years to investigate this thing and to do the right thing.
Yeah, I mean, you testified moments ago that you didn't even form an opinion on whether the officer's conduct was reasonably justified until you saw Mr. Legalu's presentation.
Well, because we're a science-based organization. So I want to make sure that I don't. First of all, I know there's no exigency in my case of investigating because the officers had already been charged. So the only thing I'm looking for is what's the court date, right? What are my dates where I know I'm going to have to come in here and testify? But other than that, I want to make sure that I've got a case that I know what the appropriate facts and circumstances are sufficient to render an ethical and moral decision within a reasonable degree of professional reliability because I know that I'm going to come in here and I'm going to visit all of you, and I'm going to give testimony, and I want to make sure that I can stand behind everything that I say to you here.
What's your business relationship to Mr. Legaloo?
He's a subcontracted employee, subcontracted expert.
Okay. And how often have you all worked together?
Well, so far, and I've been in Texas for many years, we have worked together on a number of officer-involved shootings. I think this is probably our sixth one together.
Okay. I mean, it's helpful that you guys can come as a package, right, in offering your services.
Well, yes, and just so that the jury knows, Martinelli and Associates has the only multidisciplinary forensic death investigations team in the United States. Not even the Department of Justice or the FBI has that. And so we have a law enforcement group, we have physicians, we have complete medical staff, we have forensic experts and technicians like Mr. Legaloo, and we all come together multidisciplinarily, and we put cases together. All right, so if you know Mission Impossible from the old days, like in the 70s, I'm Mr. Phelps. Okay, so that's who I am. So we form a multidisciplinary team, and when like the attorneys from CLEAT give me a call, right, and I listen to what the case is all about. I'm the guy that makes the decision of what team members I'm going to draw into the relationship to get the best and most accurate forensic product at the end. That's what I do.
Would you agree with me that a person simply holding a hammer does not make that hammer a deadly weapon?
In a static world, sure, the person just holding the hammer. It's how the person uses it through what we refer to as attendant circumstances.
So it depends on, first of all, who the person is, right? Do they have the intent to do harm with it? That's an important consideration, right?
Yeah, I would tell you yes, and non-diagnostically, we look at behavior, because behavior supports an opinion of whether or not the person is violent or whether the person intends to use the instrument to pound some nails into a roof or to injure or kill an officer.
Are you aware that roofers use nail guns and not hammers?
I'm not a roofer, but I've seen a lot of roofers use hammers. Believe you me.
So a hammer probably, in the hands of a toddler, not as big of a danger as in the hands of somebody physically larger and more athletic, correct? That's an easy question.
Well, I can see we're going to disparity of force here, and I will tell you, yes, the answer to your question is a toddler holding a hammer is not a level of threat, is a grown, stocky woman who is a roofer wielding a hammer repeatedly and attacking officers.
I mean, even if you don't even know she's a roofer.
Doesn't matter. If she's holding that hammer, she's short, she's stocky, she's dangerous, she's moving rapidly. That's a reasonable threat of serious bodily injury or death.
So to be a deadly threat, you need to find somebody with a hammer or an impact weapon such as that, right? That has the intent to seriously hurt someone, right? Has the ability to seriously hurt someone, and has the opportunity to seriously hurt someone. Would you agree with that?
Yes, and that was the case in this case. All of those things were present.
Okay. And then to use deadly force against such a person, an ordinary and prudent person, faced with a person holding a hammer, must wait until it's immediately necessary to protect themselves or another from an unlawful attack by that person. Is that correct?
That's a misstatement of the statute. It fails to include apparent danger. And
What's the
reason to
statute?
believe.
Apparent danger is not in the statute. and to use deadly force against a person. You talked about the physiological and psychological effects a human being faces or manifests, I guess, when facing a threat to their life, right?
Yes,
Kind of the OODA loop thing that we're talking about, the OODA loop.
that's right,
Say it
David.
right?
Yes, sir.
Now, these kinds of effects, this kind of release of chemicals and endorphins and stimulants and those kind of things, they're not limited to just officers facing a fear of threat, right? It happens to other people. It happens to everybody facing threats like that, right?
Correct. I think it's fair to say that Ms. Perez experienced an adrenaline dump.
And having an adrenaline dump, does it affect her judgment?
Sure it can.
Right? Does it affect her actions?
Yes.
Affect
Just
her
using adrenaline can make a person far stronger than they are and much faster than they would normally be.
Can it generate panic?
Panic? Well, we're talking about. No, I would agree with you. Sure, panic
I mean,
is.
you described
Sure,
that as
panic is a.
cause panic in the officer, right?
No, correct.
Can cause panic in the subject.
Well, I didn't see panic in the place of the officers. I saw no panic on the part of Ms. Perez. I saw a person that was the opposite of hypervigilance. I mean, we talked about hypervigilance, right? Confusion, panic, freezing. You saw none of those three, right? You saw aggressive, repeatedly attacking movements by her.
But I guess you've acknowledged that she could have been acting out of what she believed was a hopeless situation in an area of stress.
I never said that.
This is a proper area of inquiry. We've already been through this under chain analysis. And I want to recall what Mr. Norton said on that issue, and this is a backdoor way to circumvent what you ruling previously.
You can rephrase.
You mentioned a moment ago that the OODA loop isn't limited to an officer facing stress.
It's a standard response to anybody that is reacting to an acute threat.
Okay. And it could create this, I think we discussed it before, this fight or flight response.
Correct.
Right? How important was it in your conclusion that the officers acted reasonably in shooting at Ms. Perez, that Melissa Perez was a goal-oriented assailant?
I think it enhanced my opinion in that case. To see her repeatedly attacking the officers, it was a behavioral indication to me that this was not a mistake. And she was not acting in panic. She was acting with sheer deliberation. And she was goal-oriented into attacking and causing damage, serious injury, or death to these officers. It was very important to see that.
I mean, do you even have an open mind into considering that Melissa's goal in wielding the hammer was not to hurt officers, but to deter them from coming into her house?
Judge, I'm going to object. This violates the court's previous rulings on 9.41 of justifications that she also suggests officer-created danger as a defense. And it also violates the opinion in the Court of Criminal Appeals, Jeremiah Navarro versus State. And
I'll sustain. You can rephrase that.
I mean, are there facts that you watched or you observed in the investigation that Melissa's goal in wielding the hammer was to deter people from coming into her home?
Judge, I'm going to object again. I'd like to give the court a copy of this opinion. It came out yesterday.
And she didn't attack or threaten any officers not on her property, right?
Correct. She did not attack any officers that were not on her property.
And she never pursued any officers off her property with any threats, right?
Judge, again, this is a violation of the opinion in Jeremiah Navarro versus State. I can report a copy of it. It's from yesterday.
Your Honor, it's cross-examination of him describing her goal-oriented intent.
Well, it's an improper.
Let's get the opinion and then we'll go from there. All right, and so I will sustain the objection.
So officers are trained on this OODA loop, right?
Yes, sir.
Universally,
My understanding,
Right,
my
not just-
experience.
not just officers that have attended your training.
Then, Your Honor, if I may, I'd ask that the court instruct the jury to disregard all questions about what her intent was.
I'm going to instruct the jury to disregard those questions related to the complainant's intent.
This OODA loop training that you do and is done all over the country, right?
Yes.
This is standard part of the T-Cole training or anything that officers understand this dynamic,
Yes.
right? I don't know that citizens are trained on that, right?
Military people are trained in that.
Perhaps military, right? And they're trained on it so that they're better prepared to make better and safer decisions when they're having themselves in crisis situations, right?
Well, that's not what the OODA loop is intended. The OODA loop is intended simply as an officer safety technique, at least in law enforcement. The military, it's a little different, especially with fighter pilots. But for law enforcement, it's an officer safety concept that we teach them to enhance their safety.
I mean, you mentioned that you train it so that they can prepare to limit their options to avoid paralysis in the choices that they make under this stress.
Yes, I would agree with that.
It seems to me that this OODA loop discussion is more appropriate in describing an unanticipated attack than an anticipated one. Is that fair to say?
We use it mostly for acute attacks or sudden attacks, but it can be for anything. Actually, you can use it for driving, right? You can use it when you're driving. And this would be a great example. You're driving on the freeway. I think all of you that have your driver's licenses, right? When you look through the manual in Texas, they say, hey, you want to stay at X amount of miles per hour a certain car length away, right? So usually 10 miles per car length, right? So say if you're going 80 miles an hour, you really want to be a minimum of 8 car lengths behind. They're kind of teaching you the OODA loop. And then also for action, reaction, perception, lag time, outside of the OODA loop, the research begins with braking distances, right? For accident investigation and analysis. We talk about how long does it take someone under certain circumstances at certain speeds to hit the brakes so that you don't run into another car. Okay, so you all know about the OODA loop. I'm teaching you sort of a different way.
I guess getting back to my question about the difference in the facing a sudden crisis or life-threatening situation
Sure.
as opposed to an expected one. Okay.
Yes,
Does
and
that,
I believe
does that
my
shorten that time? Does it make sense to say that shortens the amount of time officers can get through that? Or expands the time?
well, if the distance is shorter, the OODA loop time is shorter, and I demonstrated that.
I'm not talking about the distance, I'm talking about the awareness of what's coming rather than the suddenness of it.
Well, yeah, because the distance creates an awareness. If you saw what I did with the defense counsel, you remember how I put him up really close and he didn't have time to respond, and then I moved back about 8 feet and then he had time to respond. So that's what I'm referring to in my response to counsel.
Okay, I mean, I'm kind of referencing if officers had already seen multiple times how she would respond to someone coming to the door, then they would have expected her to respond in a certain way when they approached the door, right?
No, not necessarily, because you have to begin the OODA loop over again each time, because remember, the first two portions of the OODA loop are observe and then orient. So when the behavior changes, here's a great example of the behavior. She had an assaultive behavior at the window, right? And then she's fired upon, and then she disengages. So we have to start the OODA loop all over again, right? What is she doing? Observing. And number two, is this going to become a threat to us? So it has to start over and over again. That's one of the problems that Ms. Perez created, not the officers.
Well, while you're talking about that, kind of discuss how this miraculous retreat of Melissa Perez after the first 5 shots was not an opportunity for officers to retreat and formulate a safer extraction.
Well, first of all, I disagree with your comment about some miraculous disengaging. That was her decision in the 5 things that a human can do when they also experience something, right?
Right.
So she got fired upon, and her first, after attacking, she got fired upon, and then her first response as a human being was not to fight at that point, but was to flee. And then we see another acute behavior that supports the goal-oriented opinion I have about her, where she immediately turned around and attacked a second time, which causes the officers to have to go through a second OODA loop.
You testified that your conclusions that Eleazar Alejandro was justified in using deadly force to protect officers Villalobos and Flores, but you did not say he was justified in using deadly force to protect himself. Is that right?
Because at that point, from everything that I've looked at, he realized that she was not presenting a threat to him because he could observe her behaviors, and the behaviors were aggressive towards Sergeant Flores. But he still, under the rules that we have of engagement, he still has, and including Texas Chapter 9, he still has a legal right, if at that point he believes that she's engaging with lethal force and that lethal intervention is immediately necessary to protect Sergeant Flores. And so under those circumstances, he fires his weapons, and I find, again, that it was an objectively reasonable decision.
Right, but you agree, you weren't making that decision as to him defending himself. You were saying his justified reason for shooting was to protect someone else.
That's an answer, yes.
Right? And likewise, you said Officer Villalobos was justified in using deadly force to protect Sergeant Flores, but you did not say you believed he was justified in using deadly force to protect himself. Is that
That's
right?
correct.
Okay. So both of those men, in your conclusions, were they didn't have a reasonable belief of imminent bodily injury or death, serious bodily injury or death, but they believed that their coworker was.
In the moment that the shots were fired, because don't forget, this is a very fluid thing. She could have attacked anyone. They are responding to what they see is an imminent threat to a colleague, which is Sergeant Flores.
Would you agree that absent a justification, if the justification does not apply, Alfred Flores would be guilty of murder, aggravated assault, and deadly conduct as a result of firing his gun multiple times at Melissa Perez that resulted in her death?
Okay, I want to make sure I understand the central focus of your question. When you say absent everything she was doing, absent her attacking, absent her being armed with a hammer, Sergeant Flores simply deciding to shoot her, that would be an unreasonable use of force.
Yeah.
That created a homicide.
Yeah. I'm saying absent the justification. If the justification fails, if he was not reasonable, did he, with intent to cause serious bodily injury or death, fire a shot into Melissa Perez that resulted in her death?
objection, improper hypothetical, argumentative, we would object under Rule 403. The way it's phrased, causes confusion, and it's also misleading, and it's cumulative and repetitive.
I'll conduct the 403 and sustain.
Were you confused by my
We'd
question?
ask that the court instruct the jury to disregard.
And instruct the jury to disregard the last question.
In your testimony about describing what Alfred Flores was thinking or feeling or perceiving, would you agree that his purpose in firing his weapon at Melissa Perez was to he have that projectile strike her with his gun,
Yes,
right? Now, the jury decides whether or not that particular conduct by him was justified or not justified.
correct.
But that is what his conduct was, right? And then his purpose was.
Yes, it's a forensic fact that he aimed at her and he fired his weapon at her and the bullet struck her.
And any officer would recognize that firing a bullet at someone creates a great risk of serious bodily injury or death.
Correct.
And that's true of Officer Alejandro, and that's true of Officer Villalobos too, in firing their weapons. From what you saw, what you heard, from what you testified that they were able to perceive, each of them, their purpose was to strike her with their bullet from their weapon.
Correct.
You'd given a statistic, I think, during direct examination about how rare it is that officers are involved in shooting people, right? Did you say 1.6%?
No, that's total uses of force out of the millions of contacts and uses of force a year by peace officers. I said that the use that an officer involved shooting, especially a fatality, the statistics are so small, they don't even approach 1%. It would be thousands of 1%.
I mean, there's lots and lots of times that police have encounters with citizens, right?
Yes.
And in a huge majority of the time, it doesn't result in the officer having to use force or using force. So that speaks to?
Yes, sir.
Thank you. I'll pass the witness, Your Honor.
Judge, we have no more questions. May the witness be excused?
Yes.
Thank you for allowing me to testify in your courtroom.
You're welcome. Thank you.
Thank you, everybody. I appreciate it. God bless you.
Your Honor, may we approach?
You can approach.
defense rests.
Your Honor, on behalf of Eleazar Alejandro, we want to make clear to the jury that we presented our case in chief through Lisa Miller and Butch Machetka, and we would rest.
All right, with that, members of the jury, we're going to go ahead and break for lunch. It's 12:52. Give you an hour and a few minutes. Come back no later than 2 o'clock, and we'll continue on. Have a good lunch.
All right for the jury?
On that basis, the charges against those defendants should be dismissed, and we believe that with respect to Alfred Flores, that his conduct was justified on all counts, and that the state has failed to disprove beyond a reasonable doubt that Alfred Flores' conduct was unjustified. And because they have failed to disprove beyond a reasonable doubt that his conduct was unjustified, the proper instruction is to inform this jury that they must find all the defendants not guilty.
Your Honor, I would like to add, I take issue with Mr. Loonan. The court, that is in fact the court's job. The court can in fact, and courts have in fact found in many cases that no rational juror in a case like this could find beyond any reasonable doubt that these officers were not justified based on all the evidence the court has heard. Once again, we've had a federal decision on the lesser standard judging the reasonableness of their actions, and we would ask the court, now that you've heard everything, it sounds like their sole rebuttal witness is an expert that they said in front of the court that they wholly disowned his opinion and he was wrong, and now they want to put him up on the stand. So I would urge the court to make the finding, because I think the evidence is in fact overwhelming, and no rational juror could in fact return a verdict of guilty based on these facts and based on the law. The last thing I want to remind the court is, which I've been saying to the court many times, these gentlemen have no vehicle whatsoever to argue to a jury that these officers acted unreasonably at the moment the deadly force was required. At the moment. They want to stretch the concept of reasonableness out to say, well, they could have left, they could have backed off. There is no law, no statute, no case law. There is nothing that would require the officers to do that. You've heard and they haven't even put up an expert in their case in chief. They put up Detective Soto, who had no training. He testified absolutely no training in use of force, whereas the defense has put up several with impeccable credentials. So once again, Your Honor, I would urge the court to direct a finding of not guilty on all three of these officers.
And Your Honor, I would also direct the court's attention to the case that I handed to the court, Jeremiah Navarro versus State. And I realize it came out yesterday, but it's on page 9 of the opinion. What they attempted, the appellant attempted to argue was that justification, Chapter 9 justification in general, permitted the appellant to resist an arrest. And what the court basically said was that the self-defense statute, and I'm reading on page 9, the self-defense statute contains an exclusion for cases in which force is used to resist arrest. And it goes on to cite the Texas Penal Code 931B2 and C. And it quotes the language, and later, after quoting all the, in quoting the language, it says, if before the actor offers resistance, the peace officer or persons acting at his direction uses or attempts to use greater force than necessary to make the arrest or search. So what we have in this case is that at the moment Melissa Perez struck the window at 20207 with the hammer, there was no evidence whatsoever that the police officers used or attempted to use greater force than necessary to make the arrest. So what that opinion says is that once Melissa Perez used unlawful force to resist arrest, that the police were authorized to use force to effectuate the arrest. And the opinion goes on later to say on page 9, the appellant fell within this resisting arrest exclusions because he resisted before the officer engaged in the conduct that appellant claims justified fighting the officer. So the fact that the appellant and Jeremiah Navarro bit the officer before the officers used any alleged excessive force compelled by the statute and Chapter 9 that he be found guilty, and so the Court of Appeals unanimously, although there were several, there was one dissenting opinion,
Court of Criminal Appeals.
All but one judge agreed that under the facts of that case, the appellant could not resist arrest and could not avail itself of the justification that now the state implicitly is trying to argue in this case. What they have essentially, through the back door, tried to argue is crazy theories that Melissa Perez was protecting her property, which is not Chapter 9, that the officers provoked the difficulty, that the officers used bad tactics, and that the force was excessive. And what this case makes clear is that even if the officers use excessive force, and once someone resists arrest, you don't have the right to resist. So we think that under the finding of Jeremiah Navarro versus State, the court has no choice but to instruct the jury to find all defendants not guilty.
The court also held you couldn't use a necessity defense once the accused in that case used any kind of force against police officers. They couldn't use the necessity defense either.
Your Honor, you've already precluded
One
the state.
final comment.
The state's sole expert
Detective Soto only testified that he had probable cause on the underlying and didn't present any evidence to refute beyond a reasonable doubt any of the various issues of self-defense. They put on no issues to rebut it. By definition, by law, through the charge of the court, this jury has to find this gentleman not guilty.
And Your Honor, that speaks to the point of the state is not resting. The case is ongoing. The state still has witnesses. It's premature to even have this hearing, considering the evidence is not closed.
Your Honor, their case in chief is closed. All we have left is rebuttal. Your case in chief is closed.
We
It's
have a
done.
right to
All right,
rebuttal.
all right, so the case in chief is closed. State, you have an argument left. Defense, you made your argument, is that right?
Yes.
Okay, I'll deny the defense motions. Anything else? All right, enjoy your lunch.
What time?
We're at the state's case in chief. State, you indicated you were going to call an expert, is that right?
Yes, Your Honor. State would call Mr. Chuck Turner.
All right. The defense requested a 705 with this expert.
Yes, Judge.
All right. Come on up, you can have a seat, sir. I'm going to swear you in.
Yes, sir.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, you may need to adjust the microphone and make sure we can all hear you, okay?
Okay.
Can you give us your name and spell it for the court reporter, please?
Chuck, C-H-U-C-K, Joyner, J-O-Y-N-E-R.
All right. You may proceed.
Mr. Joyner, I want to make sure I refer to you properly. Is it Mr. Joyner, Dr. Joyner?
Chuck is good too, but no, it's not doctor.
Not, okay, well,
Yeah.
thank you for that.
Okay.
You can call me Nico, but I don't know if they'll let you do that during court. So are you here to offer an opinion, Mr. Joyner?
I am.
And so to be specific, what subject or area are you planning to offer that opinion in?
Primarily on use of force. I could also talk about police practices and policies, but the main nexus of this trial is whether or not the use of force was reasonable.
Are you aware of the judge's rulings that they told you that you're not supposed to hear any testimony about tactics or plans or anything like that?
I have.
Okay, and so exclusively you're here to talk about use of force and whether it was reasonable.
Yes.
And so what is your opinion on that topic?
That the use of force by all three officers was unreasonable.
And so can I ask you, so what evidence did you rely on in order to come to this opinion?
I relied on the evidence that was provided to me by the district attorney's office, which included the body-worn camera videos of several officers. Is this giving you feedback?
It's a little bit. I don't know if you're too close.
It's almost, is it working now?
It doesn't work, but I can hear you.
Oh, okay. The body-worn camera of various officers, the reports prepared, the affidavits for arrest, the medical reports, witness statements.
Which witness statements and body cam did you review?
The body-worn camera videos were of the three officers, Officer Salinas, Officer Rojas, and Officer Ramos.
And Officer Rojas and Ramos was more recent though, right?
That's correct.
And Officer Rojas and Ramos has nothing to do with whether the use of force was reasonable.
That's correct.
So the body cam videos that you reviewed on what you're here to testify to is Salinas, Villalobos, Alejandro, and Flores.
That's correct. Now, the videos from Officers Ramos and Rojas did provide a different perspective of the entire situation.
But that perspective did not change whether these three officers behind us were reasonable in the use of force at the time that they used it.
That's correct. And it didn't change my opinion.
Right. So what specifically about each one of the officers was unreasonable? I mean, when you say that you reviewed the evidence, were you applying the statute as well?
Yes.
And what statutes were those?
9.31, 9.32, and 9.51, and also federal law.
Okay. Have you reviewed the federal opinion? Judge Benbrock?
The civil?
Yes, sir.
Yes, I did.
And so you disagree with the judge's opinion?
I think they misstated some of the facts. Yes, so I disagree.
And your opinion that you have not perceived some of the facts mistakenly, that's your position today?
I think they misstated some of the facts, so yes, I perceive them
So
differently.
you perceive them differently. And you feel like you reviewed all the facts?
I reviewed all the relevant facts.
And we'll talk about what that means, and what you think is relevant, but specifically as to Sergeant Flores, what specifically was unreasonable about the situation that he was in at that moment?
The short answer is he used deadly force when it wasn't warranted, when it was unreasonable.
And then with Officer Villalobos,
Same,
and then Officer Alejandro, the same.
same.
Are you aware that at some point, I mean, I'm sure you're aware that you believe that the DA's office felt that part of your opinion at least was wrong.
I am.
What part was that?
When it came to whether or not they were lawfully present and had the right to be entering her home.
And that's important when it comes to reasonableness, right? It's important to be there lawfully. I mean, you can't.
Yes, it can certainly be a factor in terms of whether or not the use of force was reasonable or not, but it also comes down to, did the officers have a reasonable belief that they were there lawfully? Did they have a good faith belief?
And you don't have an opinion on that because you're not in their minds, right?
Well, and again, it's irrelevant to this case, but you're correct.
But you believe that they were there reasonably, objectively.
Yeah, I think they had a good faith belief that they were there lawfully.
And you agree you agree that an individual, I believe it's mentioned in your report, cannot use deadly force against an officer to protect property or to resist arrest.
I don't believe so.
But not just that you don't believe so, the law states that as well, right?
That's correct, except for some circumstances, very extreme circumstances. Pretty much when you're talking about a rogue officer that's now become a criminal and is trying to kill you, and that's your only means of self-defense.
And I think the operative phrase there is very extreme, right, situation.
True, yes.
Not when an officer is lawfully there and in the commission of a lawful act. It's not.
Yeah, I would never advocate that somebody fight or try to harm a law enforcement officer.
And you agree that this situation here wasn't one of those extreme situations where an individual has a right to use deadly force against an officer?
I agree.
Yes.
Thank you, Mr. Joyner. We'll pass the pen.
All right. Did you review Dallin Young's body-worn camera video?
I'm sorry, whose?
Dallin Young.
I did not.
Okay. Did you review Travis Thompson's body-worn camera video?
I believe I did see his.
Okay. What did you see in his that informs you that the force was excessive?
I don't think, again, that didn't change my opinion looking at his. The only thing I recall from his was that he was positioned behind Officer Alejandro, and then in front of Officer Alejandro were Sergeant Flores and Officer Villalobos. That's the only thing I recall from his camera.
I'm asking you, what facts did you discern in Travis Thompson's video that told you that the force was excessive?
Nothing. Nothing new. There's no new information from his video.
So, no new information, or you didn't see any facts that in his video that told you that the force was excessive?
There was no additional information that I had not seen before when I formed my opinion.
Okay, so what specifically did you see in Travis Thompson's video that informed you that Alejandro's use of force was excessive?
I'd have to look at that video again, but I think it was the exact same thing that I saw through Officer Alejandro's video and through the other officers' videos. But if you're asking me for what the difference was between the two, I'd have to look at the videos again.
Did you write any notes to say what you saw in?
No.
No notes. Okay, did you rely upon the prosecution guide in making the decision?
I read its prosecution guide. That did not have a bearing on my opinion.
Okay. Would you agree with me that the prosecution guide did not analyze Dallin Young's body-worn camera video, it did not analyze Maria Salinas' body-worn camera video, it did not analyze Vince Gomez's body-worn camera video?
Again, I have to go through prior testimony, but I believe that's correct, that he did not use those videos.
All right, and you would agree with me that in the analysis of excessive force, you relied upon Graham v. Connor?
I did.
All right, and you understand that Graham v. Connor says the totality of the circumstances,
I
correct?
do.
And that Graham v. Connor says that that in evaluating the case, that you rely upon the severity of the crime.
That's correct.
And you rely upon the prior actions on the part of the suspect prior to officers using force.
Yes, that would be included.
All right, so what actions did you see on Vince Gomez, Maria Salinas, and other officers that would inform you what actions Melissa Perez used that were relevant to the issue of her prior conduct?
Again, I did not look at those videos.
Okay, so would you agree then that under Graham v. Connor, you would, if you haven't looked at those videos, you wouldn't be able to render an opinion about relevant conduct on the part of Melissa Perez that would inform the officers what's reasonable?
I would certainly disagree with that comment.
Okay, and tell us why.
And I think it's been mischaracterized, the totality of circumstances does not mean that you look at every possible information. What it means is that you look at relevant factors. And in Graham versus Connor, they outline what some of the relevant factors are.
And what are those relevant factors as you understand them?
There's several. One is the number of officers, the number of suspects, the size of the officers versus the size of the suspect, the tools and weapons available to the officer versus the tools and weapons available to the suspect. It may have, another factor may be the time of day. It may be the neighborhood. There could be a number of factors. But there are also factors that would not be relevant. So for example, I don't have the meteorology report from that night. I don't have the report of the sprinkling system, if the ground was wet or dry. I don't have medical reports from any of the officers as to did they feel good that day or not good that day. So all those things you can say, well, you should have seen, but to me, they're not common relevant factors. So it does not have any basis on my opinion.
All right, so you understand that Magistrate Judge Bimperot and Federal Judge Fred Berry relied upon Barnes versus Felix, which is a Supreme Court case that talked about the severity of crimes committed by the suspect is what's taken into account in the totality of circumstances. Do you agree with that standard?
The Barnes versus Felix?
Yes.
Yes, I'm aware of it.
Do you agree with it?
Yes, it reaffirms Graham versus Connor.
All right. And you agree that in Barnes versus Felix, which embraces the totality of circumstances, that you are to take into account the prior actions taken by the officers?
Yes.
And did you take that into account here?
Yes, I did.
And what prior actions did you take into account?
The actions that began with their first contact with Ms. Perez.
Can you be more specific?
The first contact with Officer Salinas, Officer Rojas, I think Officer Rojas and Officer Ramos, they had her there by the car when she took off. You had Officer Salinas and Officer Ramos trying to kick in her door, the communication attempts by them, and then going from there to her patio.
All right. Would you agree that if you did not look at the videos of Dallin Young, Vince Gomez, Maria Salinas, and others, that you cannot count the number of times the officers told Melissa Perez to come outside?
I could look at the videos that I had of the people that were there from the beginning, and I could count those numbers, and I assume it'd be identical to anybody else that was there.
Okay.
Unless Officer Young was there prior to Officer Salinas and Officer Rojas, which I understand he was not.
All right. Have you looked at all the body-worn cameras in their totality?
I have not.
All right. So would you agree that if you haven't looked at all the body-worn cameras in their totality, there's no way physically possible, mentally possible for you to count the number of times that the officers told Melissa Perez to come outside of Unit 3102?
No, I don't agree with that.
So how many times did they tell her to come out?
I'd have to look at the videos again and count. And again, at a certain point, it becomes irrelevant, because did they tell her numerous times? Yes. Did they tell her 30 times or 40 times? At a certain point, it becomes irrelevant.
All right. And so you're saying that if they told her 40 times, that's irrelevant?
Compared to 30, yes. Now, if they told her once versus 40, that is relevant. If they told her 30 versus 40, that's irrelevant.
Okay.
They told her repeatedly.
And why would it be relevant if they told her 30 times?
That they repeatedly had the attempt for her to come out and be arrested.
And what does that weigh in favor of the totality of the circumstances?
That would weigh in favor of the officers in that situation.
All right. And so what about Barnes v. Felix saying that you should consider prior actions taken by the officer, such as giving warnings or otherwise trying to control the encounter? Do you agree with that?
Yes.
All right. So what warnings or actions did the officers take trying to control the encounter?
There's several commands where they threatened to tase her if she didn't come out. They attempted to talk to her. I think at once you almost got shot by doing these things.
All right. And would you agree that the officers are entitled to take that into account when weighing the totality of the circumstances at the time they use force?
Yes.
All right. And what weight did you give on that factor on whether it was reasonable to use force?
That is a factor like many others.
So did you give that weight in favor of the officers?
Yes, that would be in favor of the officers.
All right. And would you agree that the suspect's own conduct is always relevant because it indicates the nature and level of threat the suspect possesses either to the officers or others?
That's correct.
All right, and what weight did you give to Melissa Perez's 2 hammer strikes at Jonathan Salinas and Campbell Throw, and the strike at Nathaniel Villalobos at 151.50?
Those are factors.
What weight did you give it?
The same as other factors. It's one of many.
Okay, what weight did you give it?
Are you looking for a percentage, or it's a factor that has to be considered? It's a relevant factor, yes.
All right, so did you give it significant weight, minimum weight?
No, that's a significant factor, yes.
All right. And so would you agree that the totality of circumstances also says that you look at the precise time of the shooting will often determine most how earlier facts may bear on the reasonableness of the officer?
Can you repeat that, please?
All right. So you are aware, since you did claim you read the report of Judge Bimperod, he says, of course, the situation at the precise time of the shooting will often be what matters most, but earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. You agree with that, correct?
Not entirely, because Barnes versus Felix affirms Graham versus Connor, which says it's totality of circumstances. It's not that one instance when the officers used force. And he seems to be indicating that that has greater weight than the totality of the circumstances. So I would not agree to that.
Okay. What he says is he quotes Barnes v. Felix. You understand that he's quoting
Yes.
Barnes v. Felix when he makes that statement.
I understand.
And so he's saying that it's not just the moment in time, but the prior events help decide how much of a threat it is at the moment deadly force is used.
And I agree with that.
All right. So you don't have any dispute with Judge Bimperod's ruling in that regard, do you?
No, again, I think what Barnes versus Felix did was reaffirm what Graham
That's
versus
not my
Connor
question.
said.
Do you disagree with Judge Bimperod's analysis, yes or no?
I'd have to look through the whole thing once again to see if there's anything that I disagree with, but in general, I agree with it.
All right. Do you intend to offer any opinions about the officers' tactics as vitiating the reasonableness of their belief to use deadly force?
I'm sorry, repeat it, please.
Do you understand the word vitiate?
Say that, or explain it to me.
Vitiate means to destroy or take away. Do you understand that?
Okay.
Do you tend to offer any opinions that poor tactics vitiated the officer's right to use deadly force in this case?
No.
All right. And do you have any intention to offer testimony that officer-created danger is a circumstance to consider in reasonableness?
I think that has to be considered among the totality of circumstances.
And you understand that the Supreme Court of the United States has said that's improper.
I understand that a officer's use of poor tactics does not cause him to forfeit the right to self-defense.
You agree with that?
I agree with that.
And Judge, I just had one question. Mr. Joyner, have you ever, I was going through your CD, have you ever served as a police officer before?
I have.
In what area?
I was a police officer reserve with Harris County and also with Spring Valley Village.
Is that in your CV? I saw your FBI and your...
I don't know. I believe it is. Depends on how updated the CV is.
Okay.
I'm currently...
Is that a recent job you've served in?
No. Harris County probably began in 2012, and I've been with Spring Valley, currently with Spring Valley, for the last 9 or so years.
And with Spring Valley, when you serve as a reserve, you don't go on patrol though, do you?
I did. I don't now.
How long?
How long was I on patrol?
Yes, sir.
Maybe a couple years.
Did you make traffic stops and
I did.
domestic violence calls?
No.
No. So what was the scope of your service when you were I'm sorry, I don't mean to be disrespectful. What was the PD?
Spring Valley Village.
Spring Valley Village. What was the scope of your employment there?
Primarily, it's training. If there is an emergency, such as an active shooter, I'd respond to that. If there's a weather emergency, like another hurricane, I would respond to that. But other than that, it's going to be training.
So you didn't serve as a beat cop, is what they say?
No, I did not, other than I did do some patrol with them.
Yeah, but like ride-alongs anybody can do. I'm just saying that you didn't serve in a patrol car by yourself, and they dispatched you for domestic violence or for...
I served in a patrol car with another officer, not as a ride-along, but as a certified police officer in Texas.
How many service calls did you make?
I don't know. Not many.
Under 10?
More than 10.
More than 10?
More than 10, probably less than 50.
Less than 10 to 50, you say?
Yes.
Okay. Thank you, sir.
Okay.
Tom, Christian,
Just briefly, Your Honor. Do you have a copy of your CV or your resume with you?
I don't.
Okay. The copy I have doesn't mention peace officer experience, so I just want to...
That's probably a more dated copy then.
Okay. So the report we got in 2024 didn't include your 20 teens law
And
enforcement
it's,
experience?
I have several CVs, and that's not on all of them.
Okay. How many hours would you say you spent preparing for this case?
I'd have to look at my records, over 20. For certain, over 20.
Less than 30?
Between 20 and 30.
20, 30, okay. Have you watched, I think I saw you in trial last week or the week before. Which witnesses have you watched testify?
I watched Detective Soto, and I cannot remember the name of the defense witness. It was probably your first defense witness.
Male or female?
Male.
Detective Duke?
That's it, Detective Duke.
Okay. You didn't watch any witnesses remotely through YouTube or anything?
No, I did not.
Okay. And on the reports, I just want to clarify some dates. Am I correct in your preliminary opinion was given to the state October 30th of 2023, is that right? That email?
That sounds right.
Okay. But your actual report, I didn't see a date on it. Is that, the file name shows April 18th, 2024. Does that sound right?
That may be, I mean, that would be an email. The email date would be, I assume, captured by both my email, if given the time to look through my personal emails, I may be able to find the exact date it was sent. And I don't know if the office, the DA's office, has the exact date.
That would be helpful. All I've got is the report, so I'm just trying to figure out what the date is, because it's not in the report.
It was, I know it was a while back. It was probably at least a year ago that I sent that.
Okay. And then...
Perhaps longer.
If not longer?
Yes.
Was it, do you know if it was in 2023 or 2024?
I don't.
Do you know if it was before or after the case was presented to the grand jury?
I believe it would have been before, but I can't say that with certainty.
Okay. And then we received an addendum to your initial report dated October 20th of 2025. You provided that.
Yes.
Are there any other addenda that you created?
No, it's not.
Okay. Did you, I understand you came from Austin testifying in another trial. Do you have your file with you, the information you're relying on to testify today?
My prosecutor, or my report?
Just the report, nothing else?
I do have my report.
Okay, but nothing else?
I have notes that I've taken during trial.
Okay. That's all I've got. Thank you, Your Honor.
And, Mr. Jordan, I'd just like to, do you have your CV that came with your report in front of you?
I don't.
Back at the jurisdiction. Can we help you get that? I just want to go over your total qualifications.
Sure.
What's your education?
I have a master's degree in organizational psychology. I had a double major, so I have bachelor's degrees in both biology and psychology.
Okay. And your first employment was where?
My first employment after graduate school would be with the CIA.
So you were there how long?
From 1983 to 1987.
In 1987, where'd you go?
At that point, I became a special agent with the FBI, first serving at the academy, and after the academy, I was assigned to Los Angeles.
I think everybody here will stipulate as far as like background stuff and as far as his experience, that's not really what we're questioning. We're questioning how he applied it to the facts of this case.
I do have one thought on that matter that I haven't shared yet.
Oh, okay,
Just- It only came to me just now, if I may briefly. We were not made aware that Mr. Joyner had any experience as a patrol officer or a peace officer in the state. It wasn't disclosed in the CV. Given that we're litigating a case involving peace officers in Texas and how they acted in this particular case, that would have been invaluable information to have for us to investigate and interrogate his qualifications as an expert in this particular area. It would have allowed us to get records from Spring Valley Village as to his employment, what his actual experience is, whether he's had any disciplinary issues there. We've been kind of deprived and caught by surprise now with this witness. There's really critical information that wasn't disclosed to us. We got an outdated, incomplete CV, and so feels a little bit like ambush. So we've come into this trial expecting I'll give it to him, experienced in federal law enforcement, but we had no notice that he had any experience in state law enforcement, which, as Mr. Lunan and Mr. Harrison pointed out, is the focus of this case. It's state law enforcement and their standards.
And, Your Honor, that's particularly important in this case after the people who were sponsoring him told the court that he was wrong and that they were not going to be calling him as a witness.
May I ask a few questions about? Sure. Mr. Joyner, is the CV that may have your state law enforcement experience, is it available on the internet?
I don't believe so. I believe on my website it has one of the older CVs and not the current CV. I can check right now if you'd like.
Please. Your Honor, while Mr. Joyner is looking up for the status of his current CV, I would also note what has been disclosed to defense. Page 6 of that enclosure, he's listed he's currently a licensed master peace officer in Texas, that he has been a frequent contributor to the Texas Commission on Law Enforcement, TCLO, that he is a member of the Texas Police Association, and in his previous testimony has testified in state courts on use of force against 4 officers charged and against officers so charged in several states in this district, this county, Travis County, Harris County. So there is a basis to determine he's well-versed in the application of state law.
And to be clear, Your Honor, my concern is less a matter of qualification, it's a matter of fairness and adequate disclosure of information that we're entitled to under 3914. The very fact that he's a peace officer who ostensibly has TCOL training goes to the very heart of this case. That's information that's in the sole possession of the state. We can't just go get it. It should have been turned over to us as part of the basis for this expert's opinion, and we received no notice in that regard.
You guys able to provide that to them?
It's information that we didn't have, Your Honor. Yes, we had commissioned him for a report. I don't have it. The CV that I have is posted as what was provided to the defense.
I mean, he's testified about law enforcement matters. He obviously worked as a law enforcement officer, but he hasn't provided that information to you?
The state the fact that he had state law enforcement officer did not come in the initial product, the initial CV. I did not make a subsequent inquiry from him of that. I don't believe it's any intent to deceive anyone. Simply an outdated CV came forward with the product.
So Your Honor, let me throw this in here. We received an expert report, and this goes to the failure to properly disclose information. We're hearing today that he looked at certain videos for the first time. In the first expert report, he said he looked at Salinas, Alejandro, Villalobos, and Flores body-worn camera videos, and he referenced that in the table of contents and in his report. Then, after we had the kerfuffle about they're not going to rely upon him anymore, Mr. Harris sent us an email about a subsequent conversation with this witness, and it was a disclosure under 3914, and this we asked for an addendum to the initial report. I asked for that by email because of the 3914 disclosure, and this witness wrote a report, and he said that he looked at additional videos of Officer Rojas and Officer Ramos. So what we have here is that this witness is now telling this court under oath that he looked at an additional video that's not disclosed in his expert reports. So there's been a failure to disclose information, and we asked what notes existed for Travis Thompson, and he said he had none. And if we take him at his word that he did in fact look at Travis Thompson's video, he failed to disclose that, and the state failed to disclose that in the addendum that we had asked for in the middle of this trial. So, we asked for witness disclosures and expert reports and expert information prior to the beginning of this trial, and we're giving information in the middle of trial while it's ongoing that they failed to give us at the beginning, which we were entitled to under 3914, under the due process and under the Michael Morton Act. So to permit this witness testifying now would be a manifest injustice, and we ask that he be stricken.
And just one point of clarification to kind of piggyback on what Mr. Cifuentes said. I'm not, as to the TCOL information, I'm not suggesting that the prosecutors have it and didn't give it to us. However, they are constructively in possession of any information that the government has. TCOL is a state agency. They would have an obligation under Michael Morton to get that information, whether or not Mr. Joyner volunteered it. The onus, as we all know, having done the job, is to go and procure that information. So if they know, or should know, that he was a state peace officer, that's basic information that either they should have gotten on their own or at least disclosed to us that he was a Texas peace officer so that we can make an appropriate request under 3914. We've been deprived of that ability. We're now in the middle of trial. We don't know what impact that would have had on experts we might have called, on how we might have examined our experts in this trial. We've been deprived of that opportunity, and so I endorse Mr. Cifuentes' request that Mr. Joyner not be allowed to testify.
So State, did y'all not think about getting that information, or what's the thought process?
Your Honor, Mr. Harris may have some thoughts. First of all, we went on through this in some of the discovery hearings you might remember before trial. The state has no obligation to turn over things that are not written. Okay, there has to be documents, and there are no documents that he's given us that says, I watched some other video, or Travis Thompson's video, and he doesn't have an obligation to write down that he watched a video. So that's not discoverable under Michael Morton. It includes documents, unless it's exculpatory, and it's not. It's not exculpatory. Unless it's mitigating, it's not mitigating. So this kind of demands that the defense repeatedly make that the state knew something and didn't turn it over isn't required under our discovery rules and our statutory rules with that.
It's Brady, right? I mean potential Brady, right?
Well, what they've been given, we've been reading the report that they've been given, Your Honor. It says, I am currently a licensed master peace officer in Texas. They know that. They have the ability to send out a subpoena and investigate that and get those records themselves. We don't have his birth certificate. I mean, I don't know if he was born in Texas. We don't have his school records. If he went to attend school there, and just because it went to a government, because he's affiliated with a government,
We're talking
no
about potential
obligation on
Brady,
the state.
right? We're not talking about birth certificates or school. We're talking about potential Brady, anything potentially that could have any sort of Brady material, right? You would be,
T-call, where he was employed?
yes, you would be obligated to get that, wouldn't you?
If we had it.
If it exists.
Not if it exists, if we have it. If we have it. It doesn't say if it exists. It says if the state is in possession of those
I
items.
disagree with you. I think it is required. It is required to get that information to see if there's Brady for the defense to look at.
Okay, if we have reason to believe there's a report or somewhere that provides that information, then we have an obligation to get it. If we don't have any reason to believe that there's Brady material, we can't be obligated to possess it and turn it over.
And Judge, I think
It's just not the law.
I think, with all due respect, I think Mr. Lennon is thinking of the old way of doing things. The responsibility is on them to look. So I think that the court is on the right track. It's their responsibility to look. He got close to saying it's their responsibility to do it, and it's not ours. We've all done that job. Mr. Lennon's been doing it for 37 years. The rules have changed, and the current status, the court is in the right arena, for sure, you know that, Judge, is that the responsibility is on them to check. Not if they think, because what they think is different than what we think, or we would be having this trial. Because I think they're wrong, and they think we're wrong, and so we're having a trial. So with all due respect, it's irrelevant what he thinks. It's what the law requires, and it requires for him to look to make sure, and then to turn it over and disclose it, because it could be potential Brady. We're not saying it is or isn't right now, Judge, but that's not the standard.
And Your Honor, this particular case and instance even begs for more disclosure, because frankly, I have never seen in the entirety of my career the state, and they weren't even going to tell us until they were pushed, when they go on the record and say, oh, our designated expert, he's wrong. We disagree with him. That is certainly Brady. It goes to impeachment, it goes to Brady, it goes to mitigation. And so, because of that, certainly we'd be entitled, I want to know what his training hours were via T-close, and find out what is, we didn't know. I think 16 hours is usually what reserve officers have to accrue to be a reserve officer. It all goes to his qualifications and...
All right, State, so you're making the argument that Heath does not apply in this particular situation? Is that what you're saying?
No, if there was, he says if we got evidence, we got it late. If we got it late, and we turned it over late, and we should have gotten it sooner, or we had it sooner and didn't turn it over, then the court would be able to exclude that evidence at trial. That's what Heath says. That's all that Heath says. So in that case, it was a 911 call or something of that nature. The state turned over to the defense a day or a weekend before the trial, and the state had the opportunity to get it because it was the PD had it the entire time. They're the PD that filed the case with them. And I don't disagree with Heath. Heath is fine. We have an obligation, what we have, to get it to the defense. It's something that we have, not something we don't have. Not something that's in another agency, in another county, in another state, whatever these kinds of things. Now, if we have reason to believe, because the witnesses told us, he was disciplined as a police officer in Iowa, okay? Then we'd have an obligation of going to get it and ferret that out. But we are under no obligation to look up and do a background check on every witness we have to see if they've done anything wrong. We do not.
Your Honor, I'd like to read into the record an email exchange that's very important. It was on October 19th, and it was late Sunday in the evening, close to 5 o'clock. We received an email from Darrell Harris that said ADA's David Luna and Darrell Harris had a telephone conversation with state's expert Chuck Joyner, Sunday, October 19th, 2025 at 2:05 p.m. To prepare for this call, he was provided body-worn camera footage for officers Jesus Rojas and Robert Ramos that he had not previously reviewed. We discussed his review of the additional videos and whether that changed his previous opinion. In that discussion, he told us the following, and he listed 3 things, to which I responded shortly thereafter, and I conferred with all of the team before sending this email. And they can recall that I sent this email to Mr. Harris and Mr. Luna. Since this report seems to be a material change in the export report previously provided, I trust you will provide a supplemental report from Mr. Joyner documenting his revised opinions. This supplement should be provided as part of the state's ongoing duty to comply with our previous discovery request, and the state having filed a discovery acknowledging, representing that it had provided everything to the defense. Since the state has made an affirmative representation that everything has been turned over, the state would be required to provide a supplemental report from Mr. Joyner instead of a synopsis of your notes. The only reason the state would not provide a supplemental report from Joyner would be if the state affirmatively represents that it has abandoned any attempt to use Joyner as a witness at any stage of this trial. When shall we have the supplemental report, or has the state abandoned Mr. Joyner as an expert? They provided us the report reaffirming that the only new videos were of Ramos and Rojas. If that's the case, then either this witness has misrepresented on the witness stand that he reviewed Travis Thompson, or the state has failed to disclose that Travis Thompson was reviewed, and this witness should have updated his supplemental report regardless of whether his failure to include it in the October 20th report was just a clerical error. So since they failed to update the report about Travis Thompson and what they reviewed in Travis Thompson, he should be excluded from testifying.
All right, Mr. Norton was trying to say something earlier.
Judge, actually, just one small thing, I'm going to let Mr. Newman, but the one hand they say, we should have known because he says in the report they gave us, he's a master peace officer in Texas or holds a certification. Goose and Gander, they should have known. We didn't, it never says anywhere about being employed as a reserve, where, I don't even know where Spring Valley is, I think it's in Harris County, but, I mean, who am I gonna give, I mean, it just doesn't make sense that they're shifting it to us and act like they had no obligation at all, and they do.
And I think, Your Honor, that he speaks specifically to this very circumstance.
Yeah, because it seems like the argument that Mr. Lunan was making was not an accurate rendition of what Heath holds. Am I right about that?
Just the very first paragraph of Heath, the Court of Criminal Appeals states, the question they pose is, does the mandate in Article 3914, the Michael Morton Act of the Texas Code of Criminal Procedure, that the, quote, the state produce discovery, quote, as soon as practicable after receiving a timely request, include discoverable items which, unbeknownst to the prosecuting attorney, are in the possession of law enforcement agencies. The Court of Criminal Appeals says, yes, in this context, the state means the state of Texas and includes prosecutors and law enforcement. As soon as practicable, as the phrase appears in 3914, A, means as soon as reasonably possible and does not contain a knowledge requirement on behalf of the prosecution. I'm not accusing Mr. Luna and Mr. Harris of knowing the information and failing to turn it over, but Heath makes clear that they have an obligation, unlike just a generic background check on a civilian witness. When they have a witness, particularly an expert, who was a member of law enforcement of this state, Heath makes clear they have an affirmative duty to seek out that information.
And as much as I'm salivating to cross-examine Mr. Joyner, Judge, I think it's obvious that it's your discretion to exclude him from this jury hearing from him.
I don't know if it's so much a discretion. It seems mandatory at this point.
Fair enough.
So I'm gonna sustain the defense objection. Anything else? All right, thank you, sir. Do you have any other witnesses, State?
No, we do not.
All right, so you're gonna close?
We will.
Defense closes first, should be available.
All right, so what we'll do,
Rest and close on behalf of Alfred Flores.
all right, what we'll do is we'll go ahead and bring in the jury. I'll tell the jury that we'll begin closings, the reading of the charge Monday morning, and we'll have our charge conference now, after we release the jury.
What time are you thinking went early?
Let me find out with Trish. It's gonna have to be early, yeah.
I would think so. Thank you.
reading of the charge Monday, 8 o'clock? I'll give us a full day.
Yeah.
Okay.
And just so you know, just to make, I guess, make staff members aware, I don't think 951 was in there, and so we would be asking for that.
I got an updated one.
Okay.
Let me go ahead and print that out. Am I okay if I just give the defense one charge?
One charge?
Yes.
Okay.
Yeah, your staff has been kind enough to let me scan it and I can disseminate it.
Well, if you want, I can email you this one. I can email both sides. Okay, let me do that.
So one printed, one email maybe? Right on it.
All right, let me have an email address.
In your honor, could we make one more request for the charge? We'd like a charge on 9, I think it's 932B, that she's not entitled to resist arrest, so that I know it's been mentioned here in the court, but so that the jury's instructed clearly she's not entitled to resist arrest.
All right, so that was 9.32B, and then what was the one that you brought up, Christian?
Mr. Goss mentioned 9.51. Yes. And my email's on there, Judge, on the bottom. Thank you.
You're welcome.
Nine point 31B2.
I got it. Let me get a state's email address.
B. Harris, D. Lunan, and Bear, .org.
Okay.
One second.
Ready, guys?
All right for the jury? You may be seated.
All right, State, it's my understanding that you close, is that right?
We have
Defense?
defense closes, Judge.
Defense closes.
Rest of closes.
All right, what that means is that you've now heard all the evidence that you'll get in this case. We still have to work on the law, which is the charge of the court. That's up to the court to give to y'all before you hear closing arguments of counsel. So obviously, it's too late in the day for us to do that. I'm going to ask that you be back no later than 8 o'clock a.m. on Monday. I will then read the charge. It's very lengthy. Probably going to take me about an hour to read that charge to you. That original legal document will go with you, and you'll have it with you when you deliberate in the jury room. Subsequent to my reading that charge to you, each side will have an opportunity to present closing arguments. I anticipate those will be lengthy as well. Once that is concluded, I will then formally submit the case to you to begin your deliberations, and then we will be in recess until you tell us what your verdict will be. So with that, remember the instructions I gave you. Do not do any sort of independent research. Don't look up anything online. Don't talk to anybody about this case. The next time that you hear anything related to this case should be Monday morning, 8 o'clock in the morning. All right? You have a wonderful weekend. Be safe. See you Monday.
All rise for the jury.